Is presented by Target for IQ, mentored and guided by Satendra Sir.
Welcome, aspirants. Whether you are preparing for the PCS-J, the APO, or the civil judge exams, today marks a really crucial step in your preparation.
It really does. Today, we are not just studying a statute. We are, in a way, studying the new backbone of our entire justice system.
That's a great way to put it.
We are diving deep into the Bharatiya Saksha Adhiniyam 2023, or the BSA, as we'll probably call it. This is, of course, the new act that replaces the long-standing Indian Evidence Act of 1872. And our mission today is very, very specific.
Yes, very focused. We are going to cover sections 1 to 52.
And in doing that, we're going to move from the basic definitions all the way to the complex principles of relevancy and admissibility. It's quite a journey.
It is. And as we teach at Target for IQ, the goal here is always conceptual clarity. We want you to be ready for the prelims where, they test your memory and precision.
Right, the nitty-gritty details.
Exactly. And also for the mains, where they're really testing your understanding and your ability to apply these concepts. So let's begin.
Let's do it. Let's start with slide 1, title and introduction. The visual here is quite striking. You see this heavy, formal-looking red book on the slide titled Bharatiya Saksha Adhiniyam, and it's sitting right next to a gavel.
That image really sets the tone. It represents the new law of the land. The gavel signifies authority, finality. The subject matter, as you said, is sections 1 to 52.
Okay, so let's look at the first bullet point here. It states very explicitly, replaces the Indian Evidence Act, 1872.
And that's not a small statement. We're talking about a major shift.
It really is. I mean, that's over 150 years of legal history, of precedent, of judicial thought that's now changing.
Precisely. And for you as an exam candidate, there is a key date written right here on the slide that you absolutely must memorize. It's 25th December 2023.
So that's the enactment date.
That is the enactment date. This is the date the president gave assent to the bill. It became an act on this day.
But I see a trap warning on the slide, and this seems important. It says, do not confuse the enforcement date with the enactment date.
This is, without a doubt, a classic prelims trap. It's one of the easiest marks to lose. Students, they're in a hurry, they see a date question, and they often mark the enforcement date. That's the date the act actually started being applied in courts.
Right, when it went live, so to speak.
Exactly. But the question might be asking for the enactment date. You must lock in December 25th, 2023 as the enactment date. Just, commit it to memory right now. Don't lose a mark on this simple but tricky question.
Good advice. The slide also lists the aim of the act. I'll read it. To consolidate and provide for general rules and principles of evidence for fair trial.
Let's break that down. 2 words really matter here for your understanding: consolidate and fair trial.
Okay.
Consolidate means we are bringing all the rules of evidence together into one single comprehensive code. It's about creating order.
And fair trial.
Fair trial is the soul of the act. I mean, you should ask yourself, why do we even have evidence rules? Why do we exclude hearsay? Why do we demand original documents over photocopies?
It's all to ensure that the process is just.
It is all to ensure a fair trial. If the evidence presented is unreliable or prejudicial or unfair, then justice is denied at the very outset. That's the philosophy you need to bring into your mains answers. It shows a deeper understanding.
That makes perfect sense. Let's move to slide 2. Section 1, short title, Application and Commencement. The visual on this slide is a map of India, and it has these little check marks and cross marks scattered on it. It looks almost like a flowchart of where the act applies and where it doesn't.
That's a perfect description. This flowchart is your roadmap for understanding the scope of Section 1. Let's walk through the 4 steps you can see on the slide, one by one.
Okay, first up, judicial proceedings. And that has a green check next to it.
Right. So this means the BSA applies to all judicial proceedings in or before any court. The simple test is this. If a judge is sitting, authorized to take evidence on oath, the act applies. It's the default rule book.
Okay, straightforward enough. Next, we have courts-martial, and that also has a green check.
Yes, generally it applies to courts-martial as well. Now, there are some very specific exceptions for courts that are convened under, say, the Army Act or the Navy Discipline Act. They have their own rules. But as a general principle of evidence for your exam, you should remember that the BSA does apply. The green check stands.
Now we get to the interesting part. Here come the red crosses. The third point is affidavits presented to court. And there's a big, clear red cross next to it.
This is where so many students make a mistake. It's a very common point of confusion.
I can see why. You think, well, I file an affidavit in court all the time, so surely the Evidence Act must apply to it.
And that's a logical thought, but it's incorrect. Section 1 explicitly says the act does not apply to affidavits, and we need to understand why.
Okay, why is that?
Because an affidavit is, at its core, a one-sided statement made on oath. It hasn't been tested by cross-examination yet. It's just one person's version of events. The admissibility and handling of affidavits are governed by other laws, like the Civil Procedure Code or the CRPC, not by the strict admissibility rules of the BSA, at least not initially.
So it's about the lack of testing, the lack of cross-examination.
Precisely. Now, the fourth point is proceedings before arbitrator. And we see another red cross. Yes. And the logic here is about efficiency. Arbitration is designed to be a more flexible, faster, and less formal alternative to court proceedings.
So if you force arbitrators to follow every single technical rule of the BSA,
you defeat the entire purpose of arbitration. It would become just as slow and technical as a regular court case. So the law says no, arbitrators are not bound by the BSA.
The slide also cites a case law here. Union of India VTR Varma. What does that tell us?
That case is a landmark for this principle. It basically lays down that administrative tribunals and arbitrators are not bound by the technical rules of evidence. Instead, they are bound by something else.
Which is?
The rules of natural justice. They have to be fair, they have to hear both sides, they can't be biased, but they don't need to worry about whether a piece of evidence falls under Section 6 or Section 8 of the BSA.
So, to sum this up for the exam, the slide highlights an exam alert. Remember the exclusion of arbitration proceedings, and it points out that trapped students often mark yes for affidavits.
Exactly. When you revise, just remember Section 1, subsection 2. Affidavits and arbitration are the two big exclusions you need to have at your fingertips.
Okay, let's move on to slide 3, Section 2, key definitions. Court and document. The visuals here are quite helpful. We have an icon of a lady judge to represent court, and then a really interesting collage for document. I see old scrolls, stone tablets, and then right next to them, modern computer servers.
That collage for document is very telling, especially for this new act. But let's break down court first. It's under Section 2A. The definition says it includes all judges, magistrates, and all persons who are legally authorized to take evidence. But look at the text in bold right after that.
Except arbitrators.
It circles right back to what we just discussed on the previous slide. The act is consistent. An arbitrator is not a court for the purposes of this act. That's a very likely prelims question. Simple, but you need to know it.
Got it. Now let's look at document under Section 2.2. You said this is where the new act really shines.
It does. The old definition was fine for its time. It says a document is any matter expressed on substance by letters, figures, or marks. That covers a book, a map, an inscription on stone.
But the world has changed.
Massively. And that's where the green box on the slide comes in. It highlights the crucial new addition, electronic and digital records.
The slide lists some traditional examples. 1, a writing. 3, a map or plan. 4, inscription on metal plate or stone. But then it gets to example 6, and this is the new stuff. Electronic record on emails, server logs, smartphone, locational evidence.
This is the modern relevance, and it's a game changer. Think about it. Server logs and locational evidence. If you are tracking a criminal's movements using their phone's GPS data, that data is now explicitly a document.
I see.
If you are investigating a financial fraud and you need to check a company's server logs to see who accessed a file, those logs are a document. The Act now recognizes these as primary forms of evidence, not just some secondary electronic thing that's hard to admit.
The slide also has a specific trap mention. It asks, is a caricature a document?
It's a fun one, isn't it? It seems like a trick question, but the answer is a clear yes.
Oh, why is that?
Illustration V to this section explicitly says, a caricature is a document. If a cartoonist draws a defamatory cartoon of a politician, that drawing, that expression of matter by Marx, is the document that can be used in a libel case. Don't let the word caricature fool you. It's a document.
That's a great point for the prelims. Okay, moving to slide 4. Section 2, Understanding Fact and Evidence. The visual here is very conceptual. On one side, there's an eye looking at a chess piece, and that's labeled physical fact. On the other side, there's a silhouette of a brain labeled psychological fact.
This visual perfectly captures the two types of facts defined in Section 2. Let's start with the physical fact.
The chess piece.
Yes. The definition is anything, state of things, or relation of things capable of being perceived by the senses. The chess piece on the board, a murder weapon on the floor, the sound of a gunshot you heard. These are all physical facts. You can see, touch, or hear them.
And the second type, the psychological fact, represented by the brain silhouette.
This is about what's going on inside someone's head. The definition is, any mental condition of which any person is conscious. The brain silhouette represents things like intention, fraud, good faith, or negligence. You can't see my intention, but it is a fact that exists in my mind and it can be proven through my actions.
There's a case law cited here. HP Administration v. Om Prakash.
This case is important because it clarifies that when we use the word fact in a legal context, we mean both the physical act itself, the actus reus, and the mental state behind it, the mens rea. Both are facts that need to be proved by the prosecution.
Now let's look at the definition of evidence on the same slide, under Section 2E. It's broken into oral evidence and documentary evidence.
That's the traditional classification. Oral evidence is simply the statements that witnesses are permitted or required to make before the court. Documentary evidence is all those documents we just discussed produced for the court's inspection.
But I see a modern update pointed out on the slide. This seems to be a running theme in the new act.
It is. The update clarifies that documentary evidence now, by default, includes all those electronic and digital records we mentioned. But there's another important update for oral evidence.
And what's that?
Oral evidence can now explicitly be given electronically, so a witness can testify via video conference, and their statement is considered oral evidence. The law has caught up with technology.
The trap for this slide is interesting. It says, reputation is a fact.
It sounds so abstract, doesn't it? Reputation, how can that be a fact, like a table or a chair?
Exactly.
But illustration 4 to the section's definition of fact explicitly says that a person has a certain reputation is a fact. So in a defamation case, for instance, your good reputation before the defamatory statement was made is a key fact and issue that you need to prove.
That clarifies it perfectly. Let's go to slide 5. Section 2, proved, disproved, and not proved. The visual here is the classic scales of justice, but it's balancing a document against a feather, and there's a big question mark in the center.
This visual is all about the standard of proof. It's not about absolute certainty like in mathematics, it's about probability. And the test we use is the prudent man's test.
The slide shows this as a flowchart. Let's walk through it. First, proved.
A fact is said to be proved when the court, after considering all the evidence, either believes it exists or considers its existence so probable that a prudent man, a reasonable, ordinary person, ought to act on the supposition that it exists in the circumstances of that particular case.
So it's a standard of high probability, not absolute certainty.
Exactly. Then you have disproved. That's the opposite. The court believes it does not exist or considers its non-existence highly probable.
And that brings us to the question mark in the visual. Not proved.
This is the one that's a bit tricky. Not proved is the state in between. It simply means the fact is neither proved nor disproved.
I see the trap on the slide explains this. It says, not proved does not mean false. It simply means the evidence was insufficient to cross the threshold.
And this is a vital distinction, especially in criminal law. If the prosecution fails to prove the guilt of the accused beyond a reasonable doubt, the case is not proved, and the accused is acquitted.
That doesn't mean the court is saying the accused is factually innocent.
It just means the prosecution didn't meet its burden of proof. There wasn't enough evidence to convince a prudent man. That's a critical concept for your main's answers.
Okay. The exam alert here mentions something called conclusive proof. What's that?
Conclusive proof is the highest possible standard of proof. It's a legal fiction in a way. If the act declares that one fact is conclusive proof of another, the court shall not allow any evidence to be given for the purpose of disproving it.
So it's game over, essentially.
Yep.
The door for argument is completely shut.
Completely shut. An example is Section 112 of the Old Act regarding the legitimacy of a child born during a valid marriage. The fact of the birth is conclusive proof of legitimacy, with very, very few exceptions.
That's very clear. Let's move to slide 6. Section 3, relevancy of facts. The filter. This is a great visual. It's a big golden funnel. At the top, you have all facts in the world going in. They pass through the funnel, which is labeled relevancy provisions, and only a small stream of evidence admissible comes out the bottom.
This is a concept that, as we teach at Target for IQ, is the absolute foundation of the entire law of evidence. We call it the exclusionary rule.
And what is that rule?
The slide states it clearly. The rule says, evidence may be given of two things. 1, facts in issue, that is, the main points of dispute. And 2, relevant facts, which are other facts connected to the facts in issue. And then comes the most important part.
And of no others.
Those 4 words are the filter. They are the funnel. You cannot just walk into court and dump any and all information you have onto the judge's table. Every single piece of information must first pass the test of relevancy as defined in the Act.
The slide cites the case state of Maharashtra v. Kamal Ahmed.
Hmm. This case reinforces that core principle. It says that if a fact is not declared relevant by the provisions that follow, from roughly sections 3 to 52, then it simply cannot be admitted as evidence. It doesn't matter how true you think it is or how important you feel it is.
Which brings us to the trap on the slide. It poses the question, can you give evidence of a fact just because it is true?
And the answer, which might surprise some people, is a resounding no. Truth is not the test for admissibility. Relevancy is the test. It must be legally relevant under the Act first. That is the golden rule, the filter.
A fundamental concept. Okay, let's look at slide 7. Section 4, connected facts. Same transaction. The visual is a chain, and it's linking different elements. Time A, time B, place X, and place Y.
This slide is all about the famous doctrine of res gestae. It's a Latin term that roughly means things done.
So what's the concept here?
The concept is this. Some facts are not the main point of dispute. They are not facts in issue. But they are so closely connected to a fact in issue that they form part of the same transaction. And because they are part of that chain of events, they become relevant.
The visual with the chain makes sense now. It doesn't matter if they happened at different times or different places.
Exactly. If they are links in the same chain, they are relevant. An event might start with a quarrel at one place, continue with a chase down the street, and end with an assault somewhere else. All these parts form the same transaction.
The slide mentions the case law. Javed Alam v. State of Chhattisgarh.
Yes, and this case is crucial because it gives us the modern test for res gestae. The key ingredient, the magic word, is spontaneity.
Spontaneity.
Yes. The statement or action must be so spontaneous, so immediate, that there is no time for the person to think, to concoct a story, or to fabricate a lie. It has to be an instinctive reaction to the event. If there's a gap where you could have thought about it and made something up, it's not res gestae.
The slide provides illustration A, which seems to be a classic example. A is accused of beating B. Whatever was said or done by A or B or bystanders at the beating is relevant.
Pay close attention to that word, bystanders. That's a favorite for examiners. It's not just what the victim and accused said. Even the spontaneous screams of the crowd people shouting, "Stop it," or "He's got a knife," are relevant because they are happening during the transaction. They are part of the event itself.
So the spontaneity is the key to letting those statements in.
It is the absolute key.
Let's move to slide 8, section 6, motive, preparation, and conduct. The visual is a very clear set of stairs. Step 1 is motive, step 2 is preparation, and step 3 is conduct.
This is a great way to visualize how a crime often unfolds chronologically and how the law makes each of these stages relevant.
Let's go up the stairs. Step 1, motive.
Motive is the why. It's the reason behind the act. For example, A wanted B's money. That's the motive. Evidence showing A was in deep debt would be relevant to establish this motive.
Okay. Step 2, preparation.
Preparation is the how. It's about arranging the means to commit the crime. A buys poison or a buys a gun. These acts of preparation are highly relevant.
And finally, step 3, conduct.
Conduct is the reaction. It's the behavior of a person, either before or after the crime, that is influenced by the facts. The classic example is the accused absconding or running away after the crime. That conduct is relevant.
I see a green box on the slide that says, conduct of an agent is also relevant. And the exam alert cites state, NCT of Delhi v. Navjot Sandhu.
Yes, the Navjot Sandhu case, the Parliament attack case, is very important here. It tells us that the conduct you're trying to prove must have a close nexus or a direct link with the fact and issue. You can't just bring up some random, unrelated behavior of the accused. It has to be connected.
Now, the trap mentioned on this slide seems very important. It says, statements accompanying and explaining acts are conduct. Mere statements are not conduct.
This is one of the most confusing points for many students, which is why we've actually dedicated the very next slide to breaking this down.
Perfect. So let's go to slide 9, analysis. When is a statement considered conduct? The visual here really contrasts the two ideas. On one side, you have a hand pointing with a speaker icon labeled Act Plus Statement. On the other, you just have a solitary speech bubble labeled Statement Alone.
And that visual gives you the formula you need to remember. Let me state it clearly. Act plus statement explaining the act conduct, and that is relevant. Statement alone, hearsay irrelevant under this section.
So the statement has to be tied to an action.
It has to be. Explanation 1 of the section says it very clearly. Conduct does not include statements unless those statements accompany and explain acts other than statements.
Let's make this practical with illustration, Jay, from the slide. It refers to the rape complaint scenario.
Okay, let's use that. If a woman is raped and she immediately goes to the police station to make a complaint, the act of going to the police and filing that complaint is her conduct. It's an action. And whatever she said during that complaint, the words she used to describe the incident, those statements accompany and explain her act of complaining. So the fact of the complaint and its terms are relevant as conduct.
So what's the trap here?
The trap is this. If, instead of making a formal complaint, she just tells a friend about the incident a few days later, that is not conduct under Section 6. It's just a statement. It might be relevant under another section, perhaps as a dying declaration if she dies, but it's not conduct.
So the key is the formal act of complaining. Complaint equals conduct. Mere statement does not.
That is the distinction you must remember.
Crystal clear. Let's proceed to slide 10. Section 8, conspiracy, common design. The visual is a network diagram. It shows 3 conspirators, A, B, and C, connected to a central box labeled common design.
This section is based on the principle of agency. Once you join a conspiracy, every other conspirator becomes your agent. Their actions and words done in furtherance of the conspiracy are binding on you.
What are the requirements to invoke this section?
The first requirement is that there must be a reasonable ground to believe that 2 or more persons have conspired together. You need a baseline of evidence first.
And once that's established?
Once that is established, then anything said, done, or written by any one of them becomes evidence against all of them.
But there's a crucial time frame mentioned on the slide. It says, in reference to their common intention, after the time when such intention was first entertained.
This is very important. The act or statement must have been made while the conspiracy was still active, while the common design was still in motion.
And that leads us directly to the trap, which comes from the case Yaqub Abdulrazak Memon v. State of Maharashtra.
Yes. This case makes it very clear. Any statement made after the conspiracy has ended is not admissible under this section. For example, after the police arrest all the conspirators.
Why is that?
Because once they are arrested, the common design is over. The conspiracy has been thwarted. So a confession made by one conspirator to the police after arrest cannot be used against the other co-conspirators under Section 8. It's only admissible against the person who made it.
So the timing is everything?
Everything.
Okay. Slide 11. Section 9, facts not otherwise relevant, plea of alibi. The visual is great for this. It shows 2 calendars. One says date X, crime in Chennai. The other says date X, accused in Ladakh. And there's a big red not equal sign between them.
Under the guidance of Satendra, sir, we always tell students to focus on the plea of alibi when they see this section, as it's the most common application.
Alibi, which the slide says is a Latin maxim for elsewhere.
Correct. The core idea of Section 9 is that it makes certain facts relevant, even if they aren't directly connected to the crime. One category is any fact that is inconsistent with the fact in issue.
And that's the alibi.
That's the perfect alibi. If the prosecution says the crime was committed in Chennai on January 1st, and you can prove that you were in Ladakh on January 1st, those 2 facts are fundamentally inconsistent. You can't be in 2 places at once. Your presence in Ladakh is therefore a relevant fact under Section 9.
The slide cites the case law, Darshan Singh v. State of Punjab.
A very important case on this. The Supreme Court held that a plea of alibi is a strong defense, but it must be proved with absolute certainty.
What does it mean in practice?
It means you can't just say, oh, I think I was out of town that day. That's not enough. You need concrete proof plane tickets, hotel receipts, witness testimony from where you were. The burden is on the accused to prove it strictly.
I see an exam alert here that refers to the ABCD scenario. What is that about?
This shows that Section 9 isn't just for alibis. It also covers what we call the process of elimination. Imagine a situation where it's proven that a crime must have been committed by one of 4 people, A, B, C, or D. If the accused, A, can produce evidence showing that B, C, and D were all somewhere else at the time, that evidence is relevant under Section 9. It makes the probability of A being the culprit much, much higher.
That's a very clever application of the section. Okay, let's go to slide 12. Section 12, facts showing state of mind or body. The visual is a silhouette of a head, and inside it are little icons for knowledge, a light bulb, good faith, a heart, intention, a target, and ill will, a storm cloud.
This section deals with proving the mens rea or the mental element of a crime or a civil wrong. The core rule is that any fact which shows the existence of a particular state of mind is relevant.
But there's a very important qualification in Explanation 1, which the slide highlights.
Yes, and this is crucial. The state of mind you're trying to prove must exist in reference to the particular matter in question. It cannot be about general tendencies.
And the trap on the slide says just that. General tendency is irrelevant.
Let's take an example. You can't prove that I committed murder by shooting someone by simply showing that I have a bad temper in general. That's irrelevant. You must show that I had a specific intention or ill will towards that particular victim.
But the slide points to illustration A, which seems like an exception, as accused of receiving stolen goods. Fact that he was in possession of other stolen articles is relevant.
This looks like an exception, but it's not. It's about proving a very specific state of mind. Knowledge. The fact that you had other stolen goods in your possession makes it highly probable that you knew the goods in question were also stolen. It rebuts any defense of, oh, I had no idea, I bought them in good faith.
I see. So it's not proving a tendency to steal, but proving the knowledge that the goods were stolen.
Precisely. And the slide also notes that under Explanation 2, a previous conviction can also be relevant to show a particular state of mind.
Very important distinction. Let's turn to slide 13. Section 15, admissions defined. The visual is a document that's labeled admission, and it's leading to a magnifying glass, which is labeled inference.
That visual perfectly encapsulates the definition. An admission is not a confession. It's not a direct admission of guilt.
So what is it?
Let's look at the definition on the slide. It's a statement, which can be oral, documentary, or now electronic, which suggests any inference as to any fact, an issue, or relevant fact. The key word is inference. It's a piece of the puzzle, not the whole picture.
And it must be made by specific persons, which I assume we'll cover later.
We will. But for now, just focus on that idea of suggesting an inference.
The slide brings up the case law, Kishoria Law v. Cheltabai.
This case tells us two very important things about admissions. First, they are substantive evidence. That means they have value on their own. Second, and this is important, they are not conclusive proof.
Meaning they can be explained away.
Yes. The person who made the admission can always come to court and explain the circumstances. They can say, yes, I made that statement, but it was a mistake, or I was misled, or that's not what I meant. It's strong evidence, but not unbeatable.
The exam alert also reminds us that admissions can operate as estoppels under Section 25.
That's a more advanced concept. But essentially it means if you make an admission and someone else acts on it to their detriment, you might be estopped or stopped from denying that admission later.
Okay, that makes sense. Let's look at slide 14, section 1618, who can make admissions. The visual is an organizational chart. At the top, you have party to proceeding, and then branching off are agent, suitor, person with proprietary interest, and referee.
This slide answers the question from the previous one. Who are these specific people whose statements can count as admissions? So let's list them out.
Okay, the admitters.
First, and most obviously, a party to the proceeding, the plaintiff or the defendant. Second, an agent of the party, but they must be authorized to make the statement either expressly or impliedly.
Right.
Third, a suitor in a representative character. For example, a trustee of an estate can make an admission, but only while they are acting in that capacity as a trustee. Fourth, a person with a proprietary interest in the subject matter.
And the last one is interesting. Referee under Section 18.
This one is a favorite for exam questions because it's a bit unusual. The classic illustration is on the slide. Go and ask C. C knows all about it.
What happens when you say that?
By saying that, you are appointing C as your referee for information. You are essentially telling the other party, whatever C says, I will be bound by it. So C's statement becomes an admission against you, the person who referred.
A very specific and important rule.
Very.
Okay, now for a big topic. Slide 15, Section 22. Confessions. Inducement, threat, or promise. The visual is very atmospheric. It's a dark room with a single spotlight on an empty chair, and there are words floating around it. Threat, promise, coercion.
Section 22 is the shield that protects an accused person from forced confessions. It's a cornerstone of our criminal justice system.
So what's the rule? When does a confession become irrelevant?
The slide breaks it down. A confession is irrelevant if, 1, it appears to the court to have been caused by any inducement, threat, or promise. 2, that inducement, threat, or promise must have come from a person in authority, like a police officer or a magistrate.
And there's a third condition.
Yes. The inducement must be calculated to give the accused person grounds to suppose that by making the confession, he would gain some advantage or avoid some evil of a temporal nature. For example, confess, and I'll make sure you get bail.
I see. But the slide also mentions a proviso. It says, if the impression caused by inducement is removed.
Then a confession made after that becomes relevant and admissible. For instance, if a police officer threatens an accused, but then a magistrate later assures him, "You're safe now, you can speak freely," a confession made to the magistrate could be valid.
The trap on this slide is quite surprising. A confession is not irrelevant merely because it was made under promise of secrecy or deception.
Yes, this is a fine line. The law disallows coercion, but it does allow a certain amount of trickery. If an undercover officer pretends to be a fellow criminal and gets a confession, that is admissible. Deception is allowed. Coercion is not.
A crucial distinction. This leads us to slide 16, section 23, confession to police officer. The visual is simple and powerful. A police badge with a big red band or cross sign right over it.
This section lays down an absolute blanket ban. The general ban is no confession made to a police officer shall be proved against an accused person, period.
And it goes further with the custody ban.
Yes. No confession made by any person whilst he is in the custody of a police officer shall be proved against him, unless, and there is one very important exception,
Which is?
unless it is made in the immediate presence of a magistrate.
Why does the magistrate's presence change everything?
The law presumes that if a magistrate is physically present, the police will not use any third-degree methods or coercion. The magistrate's presence acts as a judicial safeguard to ensure voluntariness.
The trap here notes that custody doesn't just mean handcuffs. It implies control or surveillance.
Absolutely. Even if you're not formally arrested, but you're in a police station and not free to leave, you are in police custody.
Okay, but there is a famous proviso to this rule. Slide 17, section 23. Proviso information leading to discovery. The visual shows a flashlight, and its beam of light is labeled information. The beam is shining on a hidden knife, which is labeled fact discovered.
This was famously Section 27 of the old Indian Evidence Act, and it is arguably the most litigated and important proviso in the entire Act. It's a favorite of examiners.
What's the core concept?
The core concept is this. When any fact is deposed to as discovered in consequence of information received from an accused in police custody,
Then what happens?
so much of such information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered, may be proved.
Let's break that down with the example on the slide. The accused says, I killed B with a knife, and I hid the knife at X place.
Okay. Following that statement, the police go to place X and they actually find the knife. The part of the statement, I hid the knife at X place, is now admissible. Why? Because the discovery of the knife confirms that part of the statement is true. He had knowledge of where the weapon was.
But what about the first part of the statement, I killed B with it?
That part is not admissible. That remains a confession to a police officer and is barred. The discovery of the knife doesn't prove who used it to kill B. It only proves the accused knew where it was. Only the part that leads distinctly to the discovery is allowed.
A very precise and limited exception.
Very. And the trap is that the fact must be discovered based on the information.
Yeah.
If the police already knew where the knife was, this section doesn't apply.
Understood. Let's look at slide 18. Analysis. Admission versus confession. The visual is a Venn diagram. There's a large circle labeled admission, and inside it, there's a smaller circle labeled confession.
But this Venn diagram says it all. The key takeaway is confession is a species of admission. All confessions are admissions, but not all admissions are confessions.
Let's compare them.
Okay. An admission is a broader term. It can be in a civil or a criminal case. It's just a statement that suggests an inference. A confession, on the other hand, is only in a criminal case. It has to be a direct admission of guilt, or at least of facts that constitute the crime.
The slide cites Sahu v. State of UP here.
Yes, that case defines a confession as a direct admission of the facts that make up the offense. It has to be an explicit acceptance of guilt.
So the trap is really the main point here. All confessions are admissions, but not all admissions are confessions.
That's the one-liner you need to remember for your exams. It perfectly summarizes the relationship between the two.
Okay, moving on. Slide 19. Section 26, statements by persons who cannot be called. The icons on this slide are very clear. A coffin for someone who is dead, a question mark for someone who cannot be found, and a lock for someone who has become incapable of giving evidence.
This section creates a major set of exceptions to the general rule against hearsay evidence. Normally, you can't tell the court what someone else told you. That person has to come to court and say it themselves.
But this section deals with situations where that's impossible.
Exactly. If the person who made the statement is now unavailable for one of the listed reasons, 1, they are dead, 2, they cannot be found, 3, they've become incapable of giving evidence, maybe due to illness, or 4, bringing them to court would cause unreasonable delay or expense.
Then what happens?
Then, their previous written or verbal statements about relevant facts can be admitted as evidence. Their statement itself becomes a relevant fact.
Okay.
And this section is just the gateway. It lists the conditions. The sections that follow give the specific instances, like dying declarations, which we'll see next.
Got it. And that brings us to slide 20, section 26A, dying declaration. The visual is an hourglass, with the sand just about to run out.
This is one of the most important exceptions. The legal principle is that a person on the verge of death is unlikely to lie.
What's the definition?
It's a statement made by a person as to the cause of his death or as to any of the circumstances of the transaction which resulted in his death.
The slide highlights a very specific condition here. It says the statement is relevant whether or not the person was under the expectation of death when they made it.
And that is the trap. This is a major difference between Indian law and English law. In England, the person must believe they are about to die.
But not in India.
Not in India. Even if you think you are going to survive, if you make a statement about how you got injured and then you later die from that injury, your statement can be admitted as a dying declaration.
The slide mentions Sudhakarvi's state of MP and also poses a key question as an exam alert. Can a conviction be based solely on a dying declaration?
And the answer is a clear yes, but with a condition. The court must be satisfied that the declaration is true, voluntary, and reliable. If it is, it can be the sole basis for a conviction without any need for corroboration.
Powerful piece of evidence then. Okay, slide 21, section 2829, Books of Account and Public Records. The visual shows a digital tablet with a spreadsheet representing modern books of account.
And this is another area where, in our judiciary classes at Target for IQ, we emphasize the updates. Section 28 deals with books of account. It says entries in such books, which are regularly kept in the course of business, are relevant. And it now explicitly includes electronic forms.
But there's a constraint mentioned. It says they are not sufficient evidence alone to charge liability.
Correct. This is a rule of caution. An entry in a ledger can be used to support a claim for a debt, but you need some other independent evidence to prove it. You need corroboration.
And Section 29 covers public records.
Yes. This is about entries in any public or official book or register made by a public servant in the discharge of their official duty. For example, an entry in a birth and death register. These are considered highly reliable and are relevant facts.
A clear distinction between private business records and public official records.
Exactly.
Let's look at slide 22, section 35, relevancy of judgments. The visual is a gavel smashing down on a document labeled Judgment in Rem.
Section 35 is about a special category of judgments. Most court judgments are in personam. They only bind the parties to that specific case.
These are different. These are judgments in rem, which means they are binding on the whole world.
Precisely. The slide lists the 4 types of jurisdiction that produce these judgments: probate, wills, matrimonial, divorce, nullity, admiralty, shipping law, and insolvency, bankruptcy.
And what is their effect?
Their effect is that they confer or take away a legal character from someone. And that judgment is not just relevant. It's conclusive proof of that legal character. If a probate court declares a will to be valid, that's it. It's valid against everyone.
The trap here is interesting. A criminal conviction is generally not relevant in a civil suit for damages.
That's right. If A is convicted of rashly driving and injuring B, B still has to independently prove A's negligence in his civil suit for compensation. The criminal conviction isn't automatically proof in the civil case.
A very important point. Moving on to slide 23, section 39, opinions of experts. The icons here are a DNA helix, a fingerprint, a book of foreign law, and an artist's palette.
This section deals with situations where the court needs help. When a court has to form an opinion on a technical subject that it's not expected to know about, like foreign law, science, art, or identifying handwriting or fingerprints, it can take the help of an expert.
And who qualifies as an expert?
The Act defines an expert as a person who is specially skilled in that particular field.
Does that mean they need a formal degree? The case state of HPV-J law is mentioned.
That case clarifies this exact point. Specially skilled does not necessarily mean you need a PhD. Experience counts. A mechanic with 30 years of experience might be an expert on a car engine, even without a formal engineering degree.
The trap here is that an expert's opinion is advisory. The court is not bound by it.
Absolutely. The expert advises, but the judge decides. The final decision always rests with the court.
And I see an important exam alert. The section now explicitly includes the examiner of electronic evidence.
Yes, another modern update, recognizing the need for experts in cyber forensics, data recovery, and so on.
Let's go to slide 24. Section 41, opinion as to handwriting. The visual is a hand with a pen, comparing a question signature to a known signature.
Now, this is important. Section 39 was about experts. This section is about the opinion of non-experts.
So who can testify under this section?
A person who is acquainted with the handwriting of the person in question.
And how does one become acquainted? The slide lists a few ways.
Yes. You are considered acquainted if you have seen that person write, or if you have received documents written by them in the course of business, or if you have habitually submitted documents to them.
The exam alert points to illustration.
And it's a great example. A merchant in Bengaluru has been receiving letters and orders from a client, B, in London for years. He's never met B, never seen him write. But because he has regularly received documents purporting to be in B's handwriting, he is considered acquainted and can give an opinion on whether a disputed signature is B's or not.
Very practical. Now for a complex topic. Slide 25, Section 4650, Relevancy of Character. The visual is a character relevance tree with branches for civil and criminal cases.
This is a tricky area. Let's start with civil cases. The general rule is that a person's character, whether good or bad, is irrelevant to prove that they did or did not do a certain act.
So you can't argue that a defendant is a bad person, therefore he must have been negligent.
Exactly. His character is irrelevant to liability. However, there's an exception. If the character itself is a fact in issue, like in a defamation case, then it becomes relevant.
And what about criminal cases?
It's different. Here, the accused is allowed to produce evidence of his good character to show that it's unlikely he would commit the crime he's accused of.
But what about the prosecution using his bad character?
That's generally irrelevant. The prosecution cannot bring up the accused's bad character unless it's in rebuttal to the evidence of good character that the accused has already put forward.
The trap here is that in civil cases, character can be relevant to determine the amount of damages.
Yes. For example, in a defamation case, a person with a very high reputation would be entitled to more damages than someone with a poor reputation. So character is relevant for damages, but not for liability.
And finally, the exam alert points to the crucial Section 48.
This is a vital protection. In cases of sexual offenses, the law now says that evidence of the victim's general character or her previous sexual experience is not relevant on the issue of consent. This is to prevent character assassination of the victim in court.
A very important and progressive provision. Let's move to our penultimate slide. Slide 26, Section 52, Facts Judicially Noticeable. The visual is a judge sitting at a bench with a thought bubble above his head saying, "I know this."
And that's exactly what judicial notice is. It's the court saying, this fact is so well known and beyond dispute that you don't need to waste time proving it with evidence. I will take notice of it myself.
The slide lists some examples from the long list in Section 52.
Yes, for example, all laws in force in the territory of India. You don't need to bring an expert to prove what the Indian Penal Code says. The judge knows it. Also, the seals of all courts and tribunals, the accession to office of public officers, these are facts the court must accept without proof.
The green box emphasizes that the court shall take judicial notice.
It's mandatory. It's not the judge's discretion. If a fact falls within the list in Section 52, the judge must take notice of it.
And the trap.
The trap is about foreign laws. The court will not take judicial notice of the laws of, say, France or Germany. If you want to rely on a foreign law, you must prove it as a fact, usually through an expert witness under Section 39.
That brings everything full circle. And now for our final slide, Slide 27. Master summary, the pyramid of proof. The visual is a golden pyramid divided into 3 layers. The base is facts, the middle is relevancy, and the top is proof.
This pyramid beautifully summarizes our entire discussion today. We started at the base with the building blocks, what is a fact, both physical and mental.
Then we moved up to the middle layer, relevancy.
Exactly, that's the filter. We looked at how facts are made relevant through being part of the same transaction, being a motive, being an admission or a confession. This is the heart of the act. Sections 3 to 50.
And finally, we reach the top of the pyramid, proof.
Where we saw how the court weighs the relevant evidence to decide if a fact is proved, disproved, or not proved. It's the logical conclusion of the entire process.
So as a final piece of advice for the aspirants listening, where should they focus their energy from this discussion?
For your mains, you absolutely must have a deep understanding of confessions, particularly Section 23 and dying declarations under Section 26. These are perennial favorites.
And for the prelims?
For prelims, focus on the definitions in Section 2 and memorize the key illustrations, especially for Sections 6, 8, and 9, and a general alert for the new Act. Always be on the lookout for where the words electronic or digital have been included. That's where new questions will come from.
Your path to the judiciary starts with the mastery of evidence. That's a powerful closing statement on the slide.
It's the truth. You can't be a good judge without being a master of evidence.
This has been a lecture presented by Target for IQ, under the guidance of Satendra Sir. We have covered a massive amount of ground today, from the basic definitions all the way to relevancy and judicial notice.
I'd encourage you to go back and review the diagrams we discussed, especially the funnel and the pyramid. Memorize the traps we pointed out, keep studying, and we'll see you in the next deep dive. Let's understand the next point from here. We are resuming our comprehensive journey through the Bharatiya Saksha Adhiniyam 2023. If you've been following our series, you know we are meticulously decoding this new act for everyone aiming for the judicial services. That's your PCS-J, APO, and civil judge exams.
Exactly. And today is a really critical session. We're entering a specific cluster of sections 49 through 56.
Okay.
And this cluster, it sort of acts as a bridge. It connects the concept of relevancy, which we've been discussing, to the next big topic, which is proof.
So it's a transitional phase in the act.
Precisely. And it is a very high-yielding area for prelims. You'll get direct section number questions. But for mains, it contains some very, very tricky conceptual pitfalls.
Pitfalls like what?
Things like the rules on character evidence, and of course the big one, hearsay.
Yeah.
It's where a lot of aspirants can get tripped up.
Right. We have a lot of ground to cover, so let's get straight into it. Let's look at the first slide on our screen. It's the title slide. Detailed analysis of sections 49 to 56. And the visual here is quite imposing. We have a backdrop that features a heavy, leather-bound law book. It's embossed with the national emblem of India, the Ashoka Chakra and Satyameva Jayate, and resting right beside it is a wooden gavel.
And you know, that visual isn't just for decoration. It's chosen very specifically. It symbolizes the authority of the court.
The power to decide.
Exactly. When we talk about these sections, we are really discussing what the court allows into its records and, just as importantly, what it keeps out. That gavel, it represents that final decision-making power.
I see the subtitle on the slide, too. It reads, Target for IQ, Mentor, and Teacher, Satendra Sir.
And that's our guiding principle for this whole discussion. It reminds us that our approach here is completely exam-oriented.
Right.
We aren't just reading the law for academic purposes. We're learning how to crack the paper, always under Satendra Sir's guidance.
Okay, let's break down the bullet points on this opening slide. There are 4 major themes for today. First up is relevancy of character, sections 49-50.
Right. And this is where we answer a very fundamental question. When does a person's reputation or their general character actually matter in a court of law?
So, for instance, if someone is accused of theft.
Yes, exactly. Does it matter that they are generally known in their neighborhood as a bad person? Or is that completely irrelevant to whether they committed this specific theft?
And I imagine the answer is different depending on the type of case.
It is. We'll see how this differs dramatically between criminal and civil cases. The rules are almost opposites.
Okay, the second bullet point is facts which need not be proved, sections 51,053. And this lists judicial notice and admissions.
This is what I like to call the efficiency engine of the law. You have to remember, courts are incredibly busy places.
Of course.
So if there are facts that are universally known, things like the laws of the land or the geography of India or facts that both parties in the case actually agree on.
Then there's no point in wasting time with evidence.
Precisely. We don't need to waste the court's precious time proving them. The court just accepts them.
Makes sense. Then we have the third point, oral evidence, sections 54-55.
Now this brings us right into the courtroom, to the witness box. Here we'll discuss spoken testimony and, as I mentioned, the very, very strict rule against hearsay evidence.
The he said, she said problem.
The ultimate he said, she said problem. And the law has a very firm stance on it.
And then finally, the last bullet point is documentary evidence, section 56.
This is really just the introduction, you could say it's the gateway section, that tells us how documents enter the legal fray.
So it sets the stage for the sections that follow.
It does. Now, as we move through all of these, you need to keep your focus really sharp. For your prelims, you are going to get direct questions asking which section covers what. Judicial notice is in which section, for example.
Okay.
But for mains, you will get complex problem-based questions. For instance, can a previous conviction of an accused be used as evidence against him? To answer that, you need to know not just Section 49, but the specific explanation within Section 49 that allows it. That's the level of detail we need.
Understood. Let's move to slide 2 then. The header is Section 49, Previous Bad Character, Criminal Proceedings. And this slide is designed as a flowchart, which should help us navigate the rule. It starts with a question box at the top. Accused has bad character.
Yes, and this flowchart is essential because the bare text of the act can be a little bit confusing on this point. So let's trace the path together. The starting question is simple. Is the accused of bad character?
Okay.
Now look at that first arrow. It points to the left, and it's labeled generally.
Right.
So if the prosecution just wants to bring up the accused bad character in a general way, you follow that arrow. And look at where it lands.
It lands in a red box. It says irrelevant.
Irrelevant. That is the fundamental rule.
Mm.
So generally speaking, a prosecutor cannot just stand up and tell the judge, Your Honor, this man is a known troublemaker. He's a criminal type, so he probably did this crime.
That would be totally prejudicial.
Absolutely. That is the general rule. Evidence of bad character is irrelevant in criminal proceedings, and you have to ask why. The reason is prejudice. If a judge or a jury hears that the accused is a bad guy, they might start thinking, well, he's done it before. He probably did it this time too. They might convict him based on his past, not on the actual evidence of the specific crime he's charged with today.
And the principle is that we try people for their acts, not for their personalities.
You've hit the nail on the head. We try people for their acts. But now, look at the second pass on the flowchart. This is where it gets interesting. It asks a follow-up question. Has evidence been given that he has a good character?
Ah, so this is when the accused himself opens the door.
He opens the door. This is the game changer. If the answer to that question is yes, meaning the accused has brought his own witnesses to the stand to say he's a saint, a pillar of the community, a peace-loving citizen, then you have to look at the green box.
It says becomes relevant.
It becomes relevant. And this is what we often call the shield and sword doctrine in legal circles.
I like that analogy. Can you expand on shield and sword?
Of course. Think of it this way. The accused uses his claim of good character as a shield. He is trying to protect himself by creating an impression that he is too good a person to have committed this crime.
Okay, so he's putting his character on the line.
He is. And the moment he raises that shield, he gives the prosecution the right to pick up the sword.
To counter his claim.
Exactly. Now, and only now, the prosecution can say, oh, you claim he is a saint. Well, let us show you his actual record. Let's talk about his real character. So it's only in reply that bad character becomes relevant.
That's a very clear distinction. Now let's look at the explanations listed on the slide. Explanation 1 says, section does not apply if bad character is itself a fact and issue.
Right, and this is a very nuanced point. Usually, as we said, character is a collateral issue. It's on the side. But in some specific cases, the character is the main issue. The character is the crime.
Can you give an example of that?
Sure. Think about security proceedings under the CRPC, or now the BNSS, for keeping the peace. Or cases involving someone being a habitual offender or belonging to a dacoity gang.
Okay. In a case of being a habitual offender, the very thing the prosecution has to prove is that the person has a bad habit of committing crimes. Their bad character is the fact in issue. So, obviously, Section 49's general ban doesn't apply there. You must be allowed to prove it.
I see. And explanation 2 says, a previous conviction is relevant as evidence of bad character.
This one is vital for the exam. Students often ask, Sir, is a past conviction considered bad character evidence? And the answer is a clear yes.
So it's not just reputation, it's a formal legal finding.
It's concrete. Under explanation 2, a previous conviction is admissible as solid evidence of bad character. So if the accused stands up and claims a clean, spotless record,
You can show the judge the previous judgment.
you can literally hand the certified copy of the previous judgment to the court. It's very powerful evidence in reply.
Now, we have some specific alert boxes at the bottom of slide 2. The first one says, corresponding law, S54 of Act 1 of 1872. This is just a quick note for those who are transitioning from the old syllabus. What used to be Section 54 of the old Evidence Act is now Section 49 of the BSA. The substance is the same, but the number has changed.
Okay, then the red box, which says, Tree A, P, In criminal cases, bad character is relevant only in reply.
This is the trap I want every single one of you to mark in your notes. In our classes at Target for IQ, Satendra Sir always emphasizes this point. The examiner will give you a problem-based question where the prosecution leads with bad character evidence first.
Before the accused has said anything about his own character.
Exactly. And that is illegal. It is inadmissible. It is only, and I repeat, only relevant in reply. You have to be very careful with the sequence of events in the question.
Got it. And the yellow box says, exam alert, previous conviction is admissible under explainer.
Again, just a reminder, do not forget this explanation. It's the legal provision that allows the concrete proof of a prior conviction to enter the court record. It's a frequently tested point.
This is a great breakdown. Let's move on to slide 3. The header is section 50, character affecting damages, civil cases. And the visual here is an equation, character, reputation plus disposition.
Right, so we're making a complete shift now. We are leaving the world of criminal law and entering civil law.
No more guilt or innocence.
No. In civil law, we are often calculating money, specifically what we call damages, which is just another word for compensation.
Okay.
And the rule, as you can read on the slide, is this. In civil cases, the fact that the character of any person is such as to affect the amount of damages which he ought to receive is relevant.
So my character can literally determine how much money I get from the court.
Absolutely. And the classic example is a defamation suit.
Okay.
Imagine a famous, well-respected actor sues a newspaper for publishing a false story that destroys his reputation. To calculate the damages, the court first needs to know, what was his reputation worth to begin with?
What was the value of what was lost?
Exactly. If he already had a terrible reputation, if he was already known as a liar and a cheat, then the damage done by this one newspaper article is probably minimal.
So he wouldn't get much compensation.
Very little. But on the other hand, if he had a spotless, pristine reputation, the damage is huge, and the compensation will be huge. So in that situation, the defendant newspaper is allowed to attack the plaintiff's character to try and reduce the final bill.
That makes perfect sense. Now let's look at that graphic again, the one about the explanation to S50. It breaks character into two distinct parts, reputation and disposition.
This is a major legal concept, and it's important to understand the difference. In English common law, historically, they only cared about reputation.
Which is what exactly?
Reputation is what other people think of you.
Yeah.
It's your public image. It's the talk of the town.
Okay, so it's external.
It's purely external. But disposition is what you actually are on the inside. It is your inherent nature, your real character, whether people know about it or not.
And what does our law say?
The BSA, following the tradition of the old Indian Evidence Act, says that character includes both reputation and disposition.
Why is that distinction important for an exam?
Because it broadens the scope of the inquiry. We aren't just asking, what do the neighbors say about him, which is reputation. We can also ask, what is his actual nature, which is disposition. It allows for a deeper level of evidence.
But there is a massive trap listed in the box below. It says, evidence of particular acts is not admissible. What does this mean?
This is the safety guard. It's a rule of fairness. You are allowed to prove a person's general reputation or their general disposition.
For example?
You can bring a witness to say he is generally known in the community to be a dishonest person. That's general reputation. But you cannot prove his character by dragging up one specific isolated incident from 10 years ago.
So you can't say he stole a pen from the office back in 2015.
No, that is a particular act. That is generally not admissible to prove his overall character. The law is looking for the general pattern of behavior, not for isolated bits of dirt you can dig up from someone's past.
That's a crucial limitation. And the exam alert at the bottom reinforces the earlier point. Exam alert. Character includes both reputation and disposition.
Yes, and this is a very frequent MCQ. The question will be framed something like, under Section 50 of the BSA, character includes A, reputation only, B, disposition only, C, both reputation and disposition, D, neither. You must mark C. It's a straightforward but easily missed point.
Understood. Let's move to slide 4. We are now entering a new part of the Act, Part 3, on proof. And the subtitle is Facts Which Need Not Be Proved.
Correct.
The header for the slide is Section 51, Fact Judicially Noticeable. The visual is really striking here. It's a 3D illustration of a judge's hand making a very firm stop gesture toward a big stack of books and documents.
I love this visual because it perfectly and instantly captures the essence of this whole section. The judge is, in effect, telling the lawyer, stop, Put those books away. You do not need to bring evidence for this. I already know it.
So the court itself provides the proof, in a sense.
Or rather, no proof is needed because the fact is so obvious. The quote on the slide reads, "No fact of which the court will take judicial notice need be proved."
What exactly is judicial notice?
Judicial notice is a legal term of art. It means the court takes cognizance, or to put it simply, acts as if it already knows certain facts. These are facts that are so notorious, meaning widely and universally known, or so clearly established by law, that proving them would be a complete waste of the court's time.
Okay, that seems straightforward. But the bottom boxes give us some important warnings. First, corresponding law S56 of Act 1 of 1872.
Just the old section number for reference.
But then the red trap box, Tree P, judicial notice is not the judge's personal knowledge.
This is probably the most critical conceptual point on this entire slide. I need you to listen to this very carefully. There is a world of difference between what a judge knows as a private individual and what he knows officially as a judge.
Okay, can you give us an example to clarify that?
Absolutely. Suppose the judge lives in a certain residential colony, and he personally knows that the accused, who happens to be his neighbor, plays extremely loud music late at night. He knows this because it keeps him awake.
Right.
Now, a nuisance case is filed against that neighbor, and it lands in this judge's court. Can the judge take judicial notice of the fact that the accused plays loud music?
I'm guessing no.
Absolutely not. That is the judge's personal knowledge.
Yeah.
Using it would create a clear bias. In fact, he should probably recuse himself from the case.
So what does judicial notice apply to?
It applies to public, universal, and indisputable facts, like the fact that the sun rises in the east, or that the rupee is the official currency of India, or that Diwali is a public holiday. Things that are not based on personal experience, but on common public knowledge.
That distinction between personal and judicial knowledge is crucial. I can see that being a tricky question in an interview.
It is a classic interview question. As we always teach at Target for IQ, interviewers love to ask, can a judge use his personal knowledge to decide a case? And the answer must be a strict, unqualified no. A judge can only use judicial notice for the specific facts that are listed in the law.
Which brings us perfectly to slide 5. The header is section 52. Facts of which court shall take judicial notice. And this slide organizes the long list from the BEAR Act into 6 visual groups.
Yes, and this is a memory aid. The list in the BEAR Act is long and, frankly, quite dry. To help you memorize it for the exam, we've grouped them visually into themes. Also, please note the word shall in the header.
It's not may, it's shall.
It's mandatory. The court has no choice in the matter. The law presumes that the court must know these things. It's part of the job description of being a judge.
Okay, let's go through these visual groups. Group 1 shows a law book and a gavel. It lists A, all laws in force in the territory of India, and the rule of the road.
Right, Clause A is the most obvious one. A lawyer doesn't need to bring a witness to prove that the Indian Penal Code or the Contract Act exists. The judge is presumed to know the law of the land.
And what about the rule of the road?
That's Clause L. It's an interesting one. It refers to the common custom that in India we drive on the left-hand side of the road. So in a traffic accident case, you don't need to bring an expert to prove this custom. The court takes judicial notice of it.
Okay, that makes sense. Group 2 shows a globe and a map of India. It lists B, international treaties, G, the national flag, and I, the territory of India.
These are all matters of state and sovereignty. The court must know the geographical boundaries of India, what is considered Indian territory and what is not. It must recognize our national flag. It must be aware of major international treaties that India is a signatory to. You don't need a surveyor to come to court to prove that Mumbai is in India.
Right. Group 3 features the Parliament building. This is for the course of proceeding of Parliament and the state legislatures.
The legislative process is a public and official act. If an act of Parliament was passed on a certain date, the court takes notice of the course of proceedings in Parliament or the state assemblies that led to that law.
Group 4 has a seal icon. This covers the seals of all the courts, notaries public, and so on.
This is a very practical provision. If a document comes to court and it is stamped with the official seal of a notary public or a high court, the judge presumes that the seal is genuine. They take judicial notice of the existence and the appearance of these official seals, so you don't have to call the notary to prove he stamped it.
Very efficient. Group 5 shows a calendar and a sun icon. This is for the divisions of time, the geographical divisions of the world, and public festivals, fasts, and holidays.
Correct. If a witness says, I saw the accused on the night of the full moon in January, The judge can simply look at a calendar or an almanac. The divisions of time, days, months, years, and all notified public holidays are judicially noticeable.
And finally, Group 6 shows cross swords representing war. This is for J, the commencement, continuance, and termination of hostilities between the government of India and any other state.
Yes, this refers to a formal state of war. If India is officially at war with another nation, the court takes notice of that fact. You don't need to call the defense minister to the witness box to testify about it.
There's an exam alert box at the bottom that points out, Clause A includes laws having extraterritorial operation.
That's an important clarification. If an Indian law, like the IPC, applies to an Indian citizen who commits a crime in, say, Paris, the Indian court hearing that case takes judicial notice of that law's extraterritorial reach.
And the trap box says, pre-AAP, don't miss clause, rule of the road.
Students often forget that one because it's tucked away at the end of the list in the BEAR Act, but it appears surprisingly frequently in MCQs. So remember these visuals we've created: the law book, the globe, the parliament, the seal, the calendar, and the swords. They will help you recall the entire list.
Great advice. Now, Slide 6 addresses a very practical problem that comes to mind. The header is Section 52.2, resorting to aids in discretion. The visual is an old reference book titled Gazetteer, with a magnifying glass placed on it.
This visual directly answers the question that I'm sure is on your mind. What if the judge simply forgets?
Exactly. They're supposed to know all this, but they're human.
They are human, and the law recognizes that. Even though the law says the judge shall know these things, Section 52 provides a practical solution. It says the court may resort for its aid to appropriate books or documents of reference.
So the judge can look it up?
The judge can pause the hearing and check a dictionary for the meaning of a word, or a calendar for a date, or an official government gazetteer for a notification. These are the aids the image refers to.
But the slide also mentions discretion. It reads, if called upon to take notice, court may refuse unless the person produces such book or document.
This part of the section balances the burden. It's not all on the judge. So if a lawyer stands up and says, Your Honor, I request you to take judicial notice that the Battle of Plassey happened on June 23, 1757, and the judge isn't immediately sure of the exact date.
You can put the onus back on the lawyer.
Precisely. The judge can say, I refuse to take notice of that specific historical fact until you, the lawyer, bring me a reliable history book that concerns it. The judge isn't denying the fact. He is simply demanding the aid before he officially acts on it.
I see. And there's a major case law box on this slide. M. Sadiq, Ram Janmakumi Temple 5J v. Suresh Das. This is the Ayodhya verdict.
It is, and this is a landmark case for evidence law, not just for its subject matter. The Supreme Court in this case had to deal with centuries of disputed history. They had to look at old gazetteers, travelers' accounts, and historical texts.
And how did they treat that evidence under this section?
They discussed this very section. The court held that while these books and gazetteers can certainly be used as aids for the court, one must exercise extreme caution. You cannot, for instance, draw a negative inference just because a traveler in the 17th century didn't mention a temple in his diary.
So they are helpful but not definitive proof.
Exactly. These books assist the court, they help form an opinion, but they are not absolute proof in and of themselves. They must always be cross-referenced and weighed with other evidence.
It's fascinating to see how a seemingly dry procedural section like this played such a critical role in a historic judgment.
It is. And, under the guidance of Satendra Sir, we always try to link these seemingly dry sections to major Supreme Court judgments. It helps you understand their real-world weight and importance.
Let's move to slide 7. The header is section 53. Facts admitted need not be proved. We have another flowchart here, this one branching out from a box that says parties or agents agree to admit.
Right. Section 53 is the great time saver of the judicial process. At its core, litigation is about disputes. There's a disagreement on facts.
One side says yes, the other says no.
Exactly. But what if both you and I agree on a certain fact? Then what?
Then there's no dispute on that point.
And if there is no dispute, there is no need for proof. It's a simple, logical principle. This flowchart shows the 3 main ways this agreement or admission can happen in a legal proceeding.
Okay, the first branch is at the hearing, and it's marked with a gavel icon.
This is the most straightforward one. It happens right there in open court. During the trial, the defense lawyer stands up and says, Your Honor, we admit that the accused was present in the city, on the night in question.
And that's it. The fact is established.
Done. That fact is now considered proven. The prosecution doesn't need to bring witnesses or CCTV footage to prove his presence anymore.
The second branch is before hearing, in writing, and this one has a contract pen icon.
This refers to various pretrial procedures. For instance, in civil cases, one party can send a list of written questions, called interrogatories, to the other. The written answers can contain admissions, or the parties can simply sign a joint document listing all the facts they agree upon.
So it narrows the scope of the trial before it even begins.
Precisely. It makes the trial faster and more focused on the real points of contention.
Now, the third branch is interesting. It's labeled by rule of pleading, deemed, with a scroll icon. That word deemed seems to be the key word here.
It is, and it's a bit tricky because this links the Evidence Act directly to the Code of Civil Procedure, or CPC.
Specifically which part?
Specifically Order 8 of the CPC. The rule is this. If a plaintiff makes a specific factual allegation in their plaint, and the defendant in their written statement does not specifically deny that allegation, if they just stay silent on that point or give an evasive denial,
Then the law treats their silence as an admission.
the law says they are deemed to have admitted it. So silence can be an admission in the context of pleadings. It's a very important rule for civil lawyers.
And the final outcome arrow for all three branches points to a box that says, no fact needs to be proved. But wait, there is a proviso mentioned right at the bottom. The court may, in its discretion, require the facts admitted to be proved otherwise than by such admissions.
This is the court's safety valve. You can call it the fraud filter.
Why is it there?
To prevent misuse. Imagine a husband and wife who both want a quick divorce, but under the law, they need a specific ground like cruelty or adultery. They might conspire, they might collude, and come to court and admit to a fake act of adultery just to get the divorce decree quickly.
So they're trying to manipulate the system.
Yes, and the court isn't blind. If a judge suspects collusion or fraud, or that the admission is being made for some improper purpose, he can use this proviso. He can say, I hear your admission, but frankly, I don't believe it. I want independent proof of this alleged fact. Admission isn't always the final word.
That leads perfectly into slide 8, which is titled Section 53 Analysis, Case Law and Limitations. And the visual is very clear. It's a title bead document with a big red X stamped over it.
That image was chosen to represent the core principle laid down in the very first case listed on the slide. MP Walkboard v. Subhan Shah. And that principle is admission cannot create title.
What does that mean in simple legal terms?
It means you cannot become the legal owner of a piece of land just because someone else admits in court that you are the owner. Property ownership and transfer are governed by strict laws, like the Transfer of Property Act and the Registration Act.
So you need beads, registration, proper procedure.
You do. You cannot bypass all those mandatory legal requirements with a simple verbal admission in court. An admission is about facts, not about creating legal rights that don't exist under the law. For admission to have weight in a property matter, it must be clear, explicit, and backed by legally valid documentation.
The second case listed is Kendriya Vidyalaya Sangathan v. Gurdharalal Yadav.
This case simply reiterates the basic rule we just discussed. It's a standard citation you can use in your answers to support the main principle of Section 53, which is that admitted facts need not be proved. It confirms the efficiency aspect.
And the third case is Union of India v. Ibrahim Uddin. This one specifically mentions Order 12 of the CPC.
Yes, this case is important because it clarifies that for an admission to be formally acted upon, especially for a judgment on admissions, it should follow the procedural rules laid out in Order 12 of the CPC. You can't just pick a random sentence from a casual letter or conversation and call it a judicial admission that can end the case. It emphasizes the need for procedural correctness.
The exam alert box gives a practical tip. It advises us to cite Waqf board for property disputes.
Absolutely. If you get a mains question that involves a property dispute where one party is relying solely on an admission made by the other side, you should first state the rule in Section 53. Then, you must immediately cite MP Waqf Board to show the limitation of that rule, that admission alone is not enough to confer title. It shows the examiner you know the nuance.
Excellent. Let's move on to slide 9. We are starting a new chapter, Chapter 4, of Oral Evidence. The header is Section 54. Proof of facts by oral evidence. The graphics here are very direct. A person speaking into a microphone with a green check mark, and next to it, a scroll document with a feather pen that has a big red X over it.
We're now shifting our focus to the medium of proof. How do you present facts to the court? Section 54 lays down the very general default rule. It says, all facts may be proved by oral evidence except contents of documents.
So broadly speaking, the default method is just to talk about what you saw or heard.
Yes. If you saw a fight, you come to court and give oral evidence. If you heard a threat, you give oral evidence. That microphone icon with the green check mark represents this general freedom to speak about facts you have perceived.
But the document has that big red X over it.
And that is the crucial exception. If you want to prove what is written in a contract, say the price of a house, you cannot just stand in the witness box and recite it from your memory. Because the law prefers the document itself. The document is considered more reliable than human memory. The document speaks for itself. So oral testimony about the contents of a document is generally barred.
And the trap box at the bottom highlights this. TRAPA, contents of documents cannot be proved by oral evidence.
This is the foundation of what lawyers call the best evidence rule. The best evidence of what a document says is the document itself. Oral testimony about it is considered secondary and therefore generally inadmissible. Section 54 draws that fundamental line. Mouths speak for physical facts. Documents speak for their own written contents.
Slide 10 takes this a step further. The header is Section 55. Oral evidence must be direct. And we have 4 icons representing the senses: an eye, an ear, a hand, and a brain.
Section 55 is the great wall that the law builds to stop hearsay. As we mentioned earlier, hearsay is when you come to court to repeat what someone else told you. The law, for the most part, hates that. And the rule is stated very simply and powerfully. Oral evidence shall, in all cases whatever, be direct.
Okay, let's break down these icons. The eye icon says, seen, witness who saw it.
This means that if the fact in issue is something visual, like a murder, a car accident, or a theft, the witness who comes to court must be the person who saw it with their own eyes.
So you can't bring a witness who says, my neighbor told me he saw the murder.
That is the classic example of hearsay. The neighbor must come to court. The person who heard it from the neighbor is an inadmissible witness on that point.
Okay. The ear icon says, heard, witness who heard it.
Same principle. If the fact is a sound, a gunshot, a scream, or a verbal statement like a threat, the witness must be the person who heard it directly with their own ears.
The hand icon says, perceived, witness who perceived it, sense touch.
This is a catch-all for the other senses: smell, touch, taste. If the fact to be proved is the room smelled of gas, the witness must be the person who was in the room and smelled the gas themselves.
And finally, the brain icon says, opinion, person who holds opinion. This seems a bit different.
It is, and it refers mainly to experts. If the fact is an opinion, for example, a handwriting expert's opinion that this signature is forged, or a ballistic expert's opinion that this bullet came from this specific gun, the expert who formed that opinion must come to court themselves.
You can't just send your assistant or submit their report without them.
Not usually. You can't have the assistant come and say, my boss, the expert, thinks it's a match. The expert who holds the opinion must come directly to state it and, crucially, to explain the grounds for it.
And the exam alert at the bottom notes that specifically. Grounds for opinion must also be proved by the holder.
Yes, an expert can't just come to court and say, in my opinion, it is a forgery. They have to explain why. I think it's a forgery because the slant of the letters, the pressure of the pen, and so on. And they must do it directly in the witness box where they can be cross-examined on those grounds.
All right, slide 11 continues this discussion. It's titled Section 55, Provisos and Hearsay Rule. The visuals are a medical book and a knife or a fingerprint.
Yes, because even the strictest rules in law usually have some exceptions. The provisos to Section 55 tell us when some form of indirect evidence might be allowed, carving out small exceptions to the direct evidence rule.
Let's look at the first proviso. It's about experts' treatises. It reads, opinions in treatises offered for sale can be proved by production if author is unavailable. Dead cannot be found.
Let's take a practical example. Imagine a world-renowned heart specialist in the UK wrote the definitive textbook on a rare heart condition. He is now deceased. In an Indian court, we have a medical negligence case that hinges on this very condition.
We can't call the expert to testify.
We can't. He's dead. So, under this proviso, we are allowed to produce his authoritative book in court. The book itself becomes the evidence of his expert opinion. This is a clear exception because we are letting the book speak for the author instead of hearing from the author directly.
That's a very necessary exception. Now, the second proviso is about material things. It says the court may require production of material thing for inspection.
This is about real physical evidence. Suppose a witness is in the box describing a weapon. He says, the knife used in the crime was long, and the handle was broken, and the blade was rusted. That is his oral evidence.
Okay.
But the court can interrupt and say, stop describing it, just show me the knife. The production of the material thing itself, the actual knife, the stolen diamond, the faulty machine part, is a form of direct proof that can be even better than a verbal description.
It bypasses the need for description.
Exactly. It's direct perception by the judge.
Then we have a major case law box, Pugdamal Gangaram v. State of Gujarat.
You should consider this case the absolute Bible for the hearsay rule in India. The Supreme Court laid down the principle in the clearest possible terms. They said, testimony based on information of another person is not admissible in absence of examination of the informant.
So if A tells B something and B comes to court,
B's testimony about what A said is hearsay and inadmissible to prove the truth of what A said. You must bring A to court. Why? Because without A on the stand, the other side has no way to cross-examine the source of the information. You can't test the truthfulness of the statement.
the green box at the bottom reminds us, treatise exception applies when calling author is unreasonable.
Yes, the core principle is reasonableness and practicality. We don't force a party to spend a fortune flying an expert from across the world for a minor point if their opinion is well documented in a standard, published, and available book.
Okay, let's move to slide 12, which is the final substantive section for today's discussion. We're now in Chapter 5 of Documentary Evidence, looking at Section 56. The visual is a tree diagram showing contents of documents branching into two paths, primary evidence and secondary evidence.
Section 56 is what I call the gateway section. It's very short, but very important. It officially concludes the topic of oral evidence and opens the door to the world of documentary evidence. It simply declares the fundamental rule. The contents of documents may be proved either by primary or by secondary evidence.
And the diagram visualizes this. The primary evidence branch shows a stack of clean original papers, and the secondary evidence branch shows a tablet or a photocopy.
Exactly. We will go much deeper into what constitutes primary and secondary evidence in our next lecture when we cover sections 57 and 58. But for now, you just need to understand this basic structure. Primary evidence means the original document itself, the actual signed contract.
And secondary.
Secondary evidence means some kind of copy, a photocopy, a certified copy from a court, a digital scan. Section 56 just establishes that these are the only two legitimate ways to prove the contents of a document in court.
There is a case law here too, Prakash v. Shanti Devi.
Yes, and this provides a very important caveat to the entire topic of documentary proof. The court held that just because a document is registered with a government authority, like a sale deed at the sub-registrar's office, that doesn't automatically make it immune to challenge.
So registration doesn't mean it's automatically true.
Exactly. The quote from the judgment is, registration does not per se render it impervious to challenge. You can still go to court and argue that a registered sale deed was signed under duress, or was obtained by fraud, or was for a transaction that never actually happened. Section 56 and the following sections help you prove that the document exists, but the truth of the transaction recorded in it can still be fought over.
And the exam alert says, start answers on documents with S56.
This is a tip for mains answer writing. It shows the examiner that you understand the structure of the act. Whenever you get a question on documentary evidence, start your answer with, as per Section 56 of the BSA, the contents of a document can be proved by primary or secondary evidence. Before you dive into the specifics of primary or secondary, it's a very professional way to begin.
That's very helpful. Finally, we have slide 13. This is the comparative analysis, old versus new. It's a simple table comparing the old Act of 1872 with the new BSA 2023 for the sections we've covered today.
This slide is really for our students who may have studied the old law before. The first message is, do not panic. For this specific block of sections, the core legal concepts are almost entirely identical. Let's run through them quickly.
Okay.
What was Section 54 on criminal character in the old Act is now Section 49 in the BSA.
Right.
What was Section 55 on civil character is now Section 50.
Mm-hmm.
The rules on judicial notice, which were in Sections 56 and 57, are now consolidated in Sections 51 and 52.
Okay.
The rule on admissions, old Section 58, is now Section 53.
Got it.
The rules on oral evidence, old Sections 59 and 60, are now Sections 54 and 55.
And the last one.
And the gateway to document proof, old Section 61, is now Section 56.
The green banner at the bottom of the slide says 100% concept retention from old Act in these sections. That's got to be a relief for many aspirants.
It is. The main task is to unlearn the old numbers and firmly memorize the new W sequence. Make a chart like the one on this slide, stick it on your study wall. The law hasn't changed, just the address where you find the law in the book.
Hmm.
As we always emphasize at Target for IQ, understanding this continuity is the key to seamlessly mastering the change.
This has been an incredibly detailed and clear breakdown. We've really covered a lot of ground, everything from the relevance of character in civil versus criminal cases, the mandatory nature of judicial notice, the strictness of the hearsay rule, and finally, the gateway to documentary evidence.
Indeed, we have covered sections 49 through 56 comprehensively. And my one piece of advice to all the aspirants listening right now is this. As soon as this section is over, go and read the Bare Act language for these specific sections. Do it immediately while all these concepts and examples are fresh in your mind.
Great advice. Thank you so much once again for guiding us through this complex but crucial part of the Act. For everyone listening, keep working hard for your judicial dreams. This is your host, along with our expert mentor, under the guidance of Satendra Sir at Target for IQ.
Let's understand the next point from here. We are about to step into a massive transformation. Usually when we talk about legal updates, we're looking at, a fresh coat of paint on an old house, maybe a new clause here, a repealed section there. But today, we're looking at a complete demolition and reconstruction of the very foundation of the Indian courtroom.
It is indeed a structural overhaul, a complete one. We are leaving behind the Indian Evidence Act of 1872, a statute that has, for all intents and purposes, governed the concept of truth in India for over 150 years. And we are entering the era of the Bharatiya Saksha Adhiniyam, or BSA, 2023.
And to navigate this, we aren't just winging it. We are diving deep into a comprehensive set of materials provided by Target for IQ. These slides were created under the guidance of Satendra Sir, and they were specifically designed for judicial services aspirants, those prepping for the PCS-J. So the level of detail we are going to hit today is, well, it's exam ready.
Exactly. Our mission today is to explore what we call the hierarchy of proof. We're focusing specifically on chapters 4, B, and 6. That covers sections 54 right through to 94. And as we teach at Target for IQ, if you don't master these sections, you simply cannot master a trial. It's the bedrock.
I really like the motto Satendra Sir has on the opening slide. Precision in law leads to perfection in judgment. It's so apt.
That is the core philosophy. It has to be. In the judiciary, ambiguity is the enemy. It's a one thing you cannot afford. You need to know exactly why a piece of evidence is admissible, or just importantly, why it must be rejected. Precision isn't just a bonus, it's the entire job description.
So for the listeners tuning in, whether you are a law student, a practicing advocate, or someone aiming for the bench, why does this specific chunk, sections 54 to 94, matter so much?
Because this is the engine room. It's everything. This covers oral evidence, documentary evidence, and the massive game-changing electronic evidence regime. These are the rules that determine whether a judge ever even gets to see your evidence. You can have the smoking gun, but if you don't know the nuances of, say, Section 63, that gun never makes it into the court record.
All right, let's jump right in then. We are starting at the base of the pyramid, Chapter 4, the realm of oral evidence. This covers just two sections, 54 and 55.
Right. Section 54 starts with what looks like a very, very wide open door. It lays down the general rule. All facts may be proved by oral evidence.
That sounds incredibly permissive. It sounds like I can just walk into court and talk about anything I want.
It does, doesn't it? It suggests that the spoken word is sufficient for truth. But, and this is a huge but, as with all things in law, there is a massive except. The section says all facts may be proved by oral evidence except the contents of documents.
This corresponds to Section 59 of the old 1872 Act, right? So the core principle isn't new.
Not at all. The logic is the best evidence rule. It's a timeless principle. If a fact has been reduced to writing, say, a contract, a will, or a deed, the writing itself is the best, most reliable evidence of what it says. Your memory of the writing or my memory is secondary and, frankly, inferior. So Section 54 creates a very clear boundary. You can speak about facts, but you cannot speak about the contents of a document if that document exists and can be produced.
The materials from Target for IQ highlight a couple of very specific case laws here to refine this point. Let's unpack Union of India v. Ibrahimuddin from 2012. What does that tell us?
This is a crucial case regarding admissions. The Supreme Court clarified that for an admission of fact to be valid within this framework, it must happen during the trial, before the hearing, or at the hearing itself. It sets a formal timeline. You can't just rely on some vague, out-of-court chatter. The admission has to be procedural. It has to be on the record to hold that specific legal weight. It's about formality.
And then there is Vice Chairman Kendriya Vidyalaya Sangathan v. Gurdaraval Yadav from 2004.
This one is really about judicial efficiency. The court held something very practical. Admitted facts need not be proved. I mean, if the prosecution and defense both agree that, yes, the accused was an employee of the school on that particular date, we don't need to waste 3 hours of the court's time bringing in HR managers and employment records to testify to that. It lets the court focus on what is actually in dispute.
Now, there's a big red box on the slide here labeled TREE-RP. I love these because this is exactly where aspirants usually lose marks.
Oh, absolutely. The trap is the exception we just discussed. Students so often remember the first part, all facts can be proved by oral evidence, and they completely forget the limitation. So the trap is, contents of documents cannot be proved by oral evidence. If you try to stand in the witness box and recite the terms of a lease deed from memory, the opposing counsel will be on their feet objecting, and the judge will and should sustain it. You need the deed itself.
Okay, that's a clear line in the sand. So let's move on to Section 55. The slides call this the Golden Rule. Why so important?
Because Section 55 is the quality filter for all oral evidence. It mandates that oral evidence must, in all cases whatsoever, be direct.
And direct is a legal term of art here. It doesn't just mean straightforward or to the point. It refers to the source of the perception, doesn't it?
Precisely. The section breaks it down into what we can think of as the four senses, or four pathways of perception. First, visual. If the fact refers to something that could be seen, the evidence must be from the witness who says, I saw it with my own eyes, not my friend told me what he saw.
Second, auditory. If the fact refers to something that could be heard, the witness must be the one who can say, I heard it.
So I can't get in the box and testify, my neighbor told me he heard a gunshot.
No, absolutely not. That is the textbook definition of hearsay. And that brings us to the exam alert case highlighted here. Phugdamal Gangaram v. State of Gujarat from 1984.
This case is a cornerstone, establishing clearly that hearsay evidence is inadmissible. The court wants the person who had the original sensory experience, not the person who heard a report about that experience. It's about getting as close to the source as possible.
What about the other senses covered?
Well, the third category is perceived by any other sense. This is the catch-all. It covers smell, touch, taste. If you are testifying that a room smelled distinctly of almonds, which might indicate the presence of cyanide, you must be the person who smelled it. You can't be the person who was told by someone else that it smelled like almonds.
And the fourth category, it's a bit different.
The fourth is opinion. This is a mental perception. If the evidence refers to an opinion like a medical diagnosis or a handwriting analysis or the valuation of a property, it must be the evidence of the person who holds that opinion on those grounds. You need the expert themselves in court to be cross-examined, not someone just reading the expert's report aloud.
But wait, there is a proviso here. This is a practical consideration. What if the expert is dead? Or what if they wrote a seminal textbook 50 years ago and now live on another continent?
That is a very practical and necessary exception. The proviso allows for experts' treatises which are offered for sale to be admitted. If the author is dead, or cannot be found, or has become incapable of giving evidence, or if calling them would cause an unreasonable delay or expense, the court can accept the treatise itself. The book, in effect, speaks for the author.
So the book becomes the witness because the human is unavailable. That makes sense.
Exactly. It prevents the loss of valuable, established knowledge just because the author has passed away or is otherwise unavailable.
There's one last key fact on Section 55 that seems important. If oral evidence refers to a material thing, the court may require its production.
Yes, and this is the court flexing its own senses. If you are describing a bloody cricket bat or a stolen diamond ring or a forged document, the court acts as the ultimate skeptic. It says, in essence, don't just describe it. If it's portable, bring it here. Let me see it. The court prefers its own inspection over your verbal description. It's an extension of the best evidence rule.
Okay, so that is the realm of oral evidence. Foundational, but with strict limits. Now we climb up the hierarchy to Chapter 5, documentary evidence. The slides call this superior proof.
And it is. This is Section 56. It simply states that the contents of documents may be proved by documentary evidence. But Section 57 is where the real machinery is. This section defines primary evidence.
In my mind, and probably for most people, primary evidence just means the original piece of paper, the first one.
In its simplest form, yes, that's a good starting point. Section 57 says primary evidence means the document itself produced for the inspection of the court. But in the modern world, the concept of the document itself can be surprisingly complex. So the BSA provides several explanations to clarify what counts as primary.
Let's go through these because Satendra Sir's notes break them down very clearly. Explanation 1. Documents executed in several parts.
Think of a standard contract signed in duplicate or triplicate. Everyone gets an original. Explanation 1 says that each of those parts is primary evidence of the document. If you have one original and I have one original, both are considered primary. There isn't one that's more original than the other.
Okay, that's straightforward. What about explanation 2? Counterparts.
A counterpart is a bit different. It's a document executed in parts where each party only signs the part that the other party keeps. The rule here is nuanced. A counterpart is primary evidence against the party executing it. So if I sign a document and give it to you, that paper is primary evidence against me because it carries my signature. Your copy, signed by you, is primary evidence against you.
Explanation 3 is the uniform process rule. This mentions printing, lithography, photography. This seems important for mass-produced items.
This is vital for mass production. It's the reason we can trust newspapers or books. If a printing press creates 1,000 placards for a protest, each one of those placards is primary evidence of the contents of all the others. Why? Because they were all created by one uniform mechanical process. If you find one, you know what all 1,000 of them said.
But, and here's the trap highlighted in the notes, are they primary evidence of the original draft?
No, and that is the distinction that catches so many people. They are primary evidence of the contents of the other placards printed at the same time, but they are not primary evidence of the original handwritten draft that the printer used to set the type. They are just copies of that draft. To prove the content of the original draft, you'd need the draft itself.
We have a case law here that seems to update this idea for a more modern office setting. Mohinder Singh v. Jaswant Kaur from 2020.
Yes, this case dealt with carbon copies, a very common thing. The court held that a carbon copy, if it is signed by both parties, assumes the character of the original document. The physical act of signing it elevates it from being just a copy in the colloquial sense to being an executed original in the legal sense.
Now, this is where the BSA really flexes its new muscles. We are entering the digital age. Explanations 4 through 7 of Section 57. This is brand new territory compared to the 1872 Act.
This is the most significant update in this entire chapter. The 1872 Act didn't know what a server was, let alone cloud storage. The BSA places digital files right at the heart of primary evidence. Explanation 4, for instance, says, if an electronic record is stored in multiple files or in multiple parts, each file or part is primary.
So if I have a Word document on my laptop and I copy it to a USB drive and I also email it to you, are all three of those primary?
Yes. Under the old mindset, we might argue about which is the original. Under explanation 4, the data itself is the entity. All of them are treated as primary. Explanation 5 goes further. An electronic record produced from proper custody is considered primary unless its authenticity is disputed. And explanation 6 is massive for criminal law. It deals with a video recording that is simultaneously stored and transmitted.
Like a CCTV camera that records to a local hard drive but also streams to a cloud server.
Exactly that. A very common scenario now. Explanation 6 says each storage point is primary. You don't need to physically retrieve the DVR from a building that burned down if the cloud backup exists. Both are treated as the original for the purpose of evidence. It's incredibly practical.
And explanation 7.
Explanation 7 acknowledges the messy reality of how computers work. It says storage in multiple spaces, including temporary files, is primary. It's the law saying, we understand that data lives in RAM, in cache, in temp folders, not just in the final saved file. We will treat all these instances as valid primary evidence.
However, despite all this digital modernization, there is a warning here in the notes about the humble photocopy. The case is Ram Suresh Singh v. Prabhat Singh from 2009.
Yes, we cannot forget the basics. This is a good reminder. This case reminds us that a Xerox or a photocopy, in the absence of the original, is not admissible without laying the proper groundwork first. You cannot just waive a photocopy in court and call it primary evidence. It is, by its very definition, secondary. You have to explain why the primary is not available.
Which brings us perfectly to the next section. If you don't have primary evidence, you have to rely on secondary evidence. This is Section 58.
Section 58 is the substitute bench. It gives us an exhaustive, closed list of what qualifies as secondary evidence. First, certified copies. This is the gold standard for public documents. Second, copies made from the original by a mechanical process that ensures accuracy, like a photocopy or a photograph. Third, copies made from or compared with the original. Think of a clerk making a handwritten copy and then having a second person check it against the original for accuracy. Fourth, counterparts, but this time against the parties who did not execute them. And fifth, and this is the only oral form, oral accounts of the contents by a person who has personally seen the document.
There's a big exam alert on the slide here. There is a new addition to this list in the BSA, which wasn't as explicit before.
Yes, this is critical for aspirants to note. Oral admissions and written admissions regarding the contents of a document are now explicitly listed in Section 58 as forms of secondary evidence. This clarifies that if you, in a written pleading or in oral testimony, admit to the contents of a lost contract, that admission itself can be used as valid secondary evidence of what was in that contract.
And the case law, J. Yashoda v. K. Shobarani from 2007, is cited here. What's its significance?
That case is the boundary wall. It clarifies that the definition of secondary evidence in the Act is exhaustive. It's a closed list. You cannot invent a new type. If your evidence doesn't fit into one of these specific buckets in Section 58, it is not secondary evidence, period.
Okay, so we know what secondary evidence is, but you can't just use it whenever you feel like it. You have to pass the admissibility test. This is Section 60.
Exactly. Section 60 lays out the 7 gateways. You can only use secondary evidence if you can prove you fit into one of these 7 specific situations. The law always prefers the best evidence, which is primary, so you need a valid excuse to use the substitute.
Let's walk through the 7 cases, the 7 gateways.
All right. The first and most common is Clause A, possession. The original is with your adversary, or someone who is out of reach of the court, or someone who is legally bound to produce it but refuses to do so. Basically, you physically cannot get it. Clause B, admission. The existence of the contents has been admitted in writing by the adverse party. In that case, their own admission can be used. Third, Clause C, destruction. The original has been destroyed or lost. And a crucial writer here, it must not have been destroyed or lost due to your own default or neglect. You can't benefit from your own carelessness.
Okay, what's next?
Clause D, nature. The original is not easily movable. Think of an inscription on a huge tombstone or a carving on a public monument. You can't bring the Taj Mahal to court to read the inscription. A photograph or a certified rubbing would be allowed. Then E and F are related. Clause E is when the original is a public document under Section 74, and Clause F is when the original is a document for which a certified copy is permitted by law. In these cases, we rely on certified copies to protect the originals. And finally, G, volume. This is for numerous accounts or other documents. If you have 10 years of a company's financial ledgers, you don't bring a truckload of paper to the courtroom. You can have an expert summarize the general result.
There's a very strict rule for gateways E and the public and certified documents.
Yes, an important one. In those 2 cases, a certified copy is admissible, but no other kind of secondary evidence is allowed. You can't bring a hand-copied transcript of a public deed, nor can someone give oral evidence of its contents. It must be a certified copy. The procedure is rigid.
Now, for Gateway A, where the adversary has the document, you need to follow a specific procedure. You can't just surprise them in court and say, I'm using secondary evidence because you have the original.
Correct. That would be an ambush. The procedure is laid out in Section 64, notice to produce. The rule is that you cannot give secondary evidence under clause unless you have first given a formal notice to produce to the party holding the document. You must ask for the original first.
But there are exceptions where a notice is not required. Common sense exceptions, it seems.
Yes, logic prevails here. You don't need to give many one. Notice if, for instance, the document you want to prove is itself a notice. You don't need a notice to produce a notice. Or if the adverse party knows they must produce it, like in a trial for the theft of that very document. Also, if they obtained possession by fraud or force, if they have the original in court right there with them, if they have already admitted it's lost, or if the person holding it is simply out of the court's reach.
The slide has a trap here that seems very important for exam purposes. Notice is required only for Section 60A. It is not required for destroyed or lost documents.
That is a very common exam mistake. Students mix up the conditions. If the document is lost or destroyed under Section 60C, you don't send a notice. I mean, who would you even send it to? The universe. No. You just have to prove the loss to the court's satisfaction, and then you're free to bring in your secondary evidence.
All right. We have built the foundation of oral and documentary evidence. Now we're going to talk about the biggest shift, the true paradigm shift in the BSA, the new electronic evidence regime.
This is it. This is the big one. We are moving from the often confusing Section 65B of the old Evidence Act to the new streamlined Sections 61, 62, and 63 of the BSA.
Section 61 contains something called a non-obstant clause. What does that mean in plain English for our listeners?
It's a legal term for an overriding provision. It means notwithstanding anything else contained in this act. It's a powerful tool. Section 61 explicitly states that nothing in this adhenium shall deny admissibility to an electronic record just because it's electronic. It gives digital records the same legal effect, validity, and enforceability as paper documents.
So it completely levels the playing field between paper and pixels.
It does. It's a declaration of technological neutrality. But while Section 61 opens the front door, Section 63 stands as the security guard at that door. Section 62 says the contents of electronic records may be proved in accordance with the provisions of Section 63. So 63 is the key.
Let's break down Section 63 then. It outlines the path from raw information to admissible evidence.
The flow is exactly that. Information is fed into a computer or device. If certain conditions are met, the output becomes evidence. Section 63, subsection 2, lists 4 conditions that must be met for that computer output to be trusted by the court. 1, the device was used regularly to store or process information for a lawful activity. 2, the information was regularly fed into it in the ordinary course of those activities.
So it's about routine and regularity.
Yes. 3, the computer was operating properly. Or if it wasn't, the failure didn't affect the accuracy of the electronic record. And 4, the information you're presenting either reproduces or is derived from the information that was originally fed into the computer. It has to be a faithful representation.
And the definition of computer in Section 63, it seems quite broad.
It is extremely broad and intentionally so. It includes standalone units, systems, networks, or even an intermediary. It's future-proof. It covers everything from a simple smartwatch to a complex global server farm.
Now, the big question, the certificate. Under the old law, the Section 65B certificate was a constant source of litigation and confusion. Is it still there?
It is. It's in Section 63, subsection 4.
Right.
And it is still the mandatory certificate. In any proceeding where you want to submit an electronic record, a certificate must be submitted along with it that does 3 things. 1, it identifies the electronic record. 2, it gives the particulars of the device that produced it. And 3, it certifies that the conditions we just talked about, regular use, proper operation, are met.
And who signs this crucial document?
It must be signed by a person who is in a position of responsibility, either a person in charge of the computer or device, or the management of the relevant activities. This is slightly broader than before, which is a practical improvement, allowing a manager who oversees the system to sign off.
The slide very helpfully walks us through the judicial analysis, or the history of this certificate. It's been a bit of a roller coaster.
It's a fascinating story of a Supreme Court wrestling with technology. It went back and forth. In 2014, in Anwar PV Pikigo Bashir, the court laid down a strict rule. The certificate is mandatory. No certificate, no evidence. Simple as that.
But then it changed.
Yes, in 2018, in Shafi Mohammed, the court seemed to soften the stance. It held that the requirement could be relaxed, especially if the party trying to produce the evidence didn't own the device, like CCTV footage from a third party. But then, in 2020, the larger bench in Arjun Panitral Kotker stepped in. It overruled Shafi Mohammed and went right back to the strict rule in Anwar PV. The court confirmed the certificate is a condition precedent to admissibility. The law is now settled and strict.
So we're back to very strict rules. But there is a Chafi trial noted from that Arjun Panitral judgment, a very important nuance.
Yes, and this is a point we emphasize constantly under the guidance of Satendra Sir. The certificate is mandatory if the party is not in possession of the original device. If you bring the actual laptop into court, the physical device itself, that device is primary evidence. You don't need a certificate for the device itself. But if you bring a printout of an email or a copy of a file on a pen drive, that is secondary evidence. And to prove that secondary copy is authentic, you need that certificate.
That is a vital distinction for practitioners. It's about what you're presenting. If you have the phone, submit the phone. If you only have a screenshot from the phone, you absolutely need the certificate.
Precisely. That's the takeaway.
Okay, let's move on to a more traditional area, but one with digital updates. Proof of signature and handwriting, which is covered in sections 65 to 73.
Section 65 is the general common sense rule. If a document is alleged to be signed by someone, you must prove that the signature is in their handwriting. The court doesn't just assume it.
And section 66 handles the modern equivalent, electronic signatures.
It essentially mirrors the paper rule. An electronic signature must be proved to be that of the subscriber. The only exception is for a secure electronic signature, which comes with its own set of legal presumptions about its validity.
What about witnesses? We often see this in movies, the attesting witness. Section 67 talks about attestation.
Section 67 says that if a document is required by law to be attested, it shall not be used as evidence until one attesting witness at least has been called. But, and this is a huge but, look at the key fact highlighted in the proviso. For registered documents, like a sale deed, which are not a will, you do not need to call an attesting witness to court unless the execution of that document is specifically denied by the other side.
That must save a lot of court time.
Yeah.
You don't need to hunt down witnesses for every standard registered property transaction. Now, Sections 72 and 73 are about verification by the court itself.
Yes, Section 72 allows the court to play detective, in a way. It can direct any person present in court to write words or figures or to give their finger impressions so the court can compare them with the disputed signature or impression. And Section 73 is the digital equivalent. It's very modern. It empowers the court to interact with the certifying authority. The court can direct the controller of certifying authorities to produce the digital signature certificate to verify someone's digital identity.
That's quite a powerful tool. Moving on to a fundamental classification, public versus private documents in Section 74.
Section 74(1) gives a clear definition of public documents. It's basically the official paperwork of the state. It includes acts or records of the sovereign authority, of official bodies and tribunals, and of public officers, whether legislative, judicial, or executive. And crucially, it also includes public records kept in any state of private documents.
And Section 74(2) is simple enough.
Yes, it just says all other documents are private. If it's not on the public list, it's private.
The case law, Deccan Paper Mills Co., Ltd. Regency Mahavir Properties, is cited here to clarify that line.
It clarifies a very common point of confusion. A registered private document, like a sale deed between you and me, is not itself a public document. It remains a private contract. However, the entry made in the registrar's book about our sale deed is a public document. The record is public, even if the underlying document is private.
Now we get into presumptions in Chapter 5. This is where the law gives you a bit of a head start in proving your case.
Yes, and we are looking specifically at the shall presume sections. This is a mandatory presumption. The court must assume the fact is true unless and until it is disproved. Section 78. The court shall presume the genuineness of certified copies. Nation 79. The court shall presume documents produced as a record of evidence are genuine. And Sections 80 for paper and 81 for electronic records. The court shall presume the genuineness of official gazettes.
The case of M. Sadiq, the Ram Janmabhoomi Temple case, is mentioned here.
Yes, the Supreme Court in that case reaffirmed that gazettes have high probative value. If something is published in the official gazette, the court takes it as an official, authentic fact. But there is a trap noted in Section 81 regarding electronic records. The concept of proper custody for electronic records means they have to be in the place they ought to be. Just because a file is online somewhere doesn't automatically mean it's in proper custody.
We also have shall presume provisions for maps made by government authority in Section 82, collections of laws in Section 83, and powers of attorney in Section 84.
Section 84 is very useful in practice. If a power of attorney is executed before and authenticated by a notary public or any court or judge, the court shall presume it was so executed and authenticated. It saves a lot of hassle.
Then we have a block of sections on electronic agreements, Sections 85 to 87.
Yes, Section 85 presumes that electronic agreements concluded with an electronic signature are validly concluded. Section 86 presumes that secure electronic records haven't been altered since the point in time to which the secure status relates. But the trap in Section 86(2)(b) is critical for exams. For secure signatures, the presumption relates only to the affixation of the signature by the subscriber. It does not relate to the truth or accuracy of the contents of the record. In other words, I can securely sign a document full of lies. The law only presumes that I was the one who signed it, not that the lies are true.
Now we reach a section the slides call the time capsule. This is a fascinating comparison between an old presumption and a new digital one.
This is Section 92 versus Section 93. It's a perfect illustration of how the law is adapting. Section 92 keeps the old 30-year rule for paper documents. If a document is proved to be 30 years old and is produced from proper custody, the court may presume, it's discretionary, that the signature and handwriting are genuine. The case law Om Prakash v. Shanti Devi from 2015 is key here. It held that the 30-year period is reckoned backwards from the date the document is filed in court. And the court said a relaxation, even by a few months, is not permissible. It's a strict 30 years.
And then we have the new rule in Section 93.
Yes, Section 93 introduces the 5-year rule for electronic records. If an electronic record is proved to be 5 years old and is from proper custody, the court may presume that the electronic signature was affixed by the subscriber or by someone authorized by them.
30 years versus 5 years, that's a huge difference.
It is, and it's a recognition of the speed of technological change. 5 years in the digital world can feel like an eternity. But the big trap for students, of course, is confusing the two time limits. It's simple. 5 years for digital, 30 for paper. A perfect MCQ question.
Finally, we arrive at our last major topic for this deep dive. Chapter 6, Exclusion of Oral by Documentary Evidence, which is primarily Section 94.
This brings us full circle, back to the best evidence rule we started with. This is the exclusionary rule. It says that when the terms of a contract, grant, or other disposition of property have been reduced to the form of a document, and no oral evidence shall be given in proof of those terms, except the document itself, or secondary evidence of its contents where that's admissible. Simply put, the writing trumps the speech. The document speaks for itself.
Are there any exceptions to this strict rule?
There are a couple. The appointment of a public officer required by law to be in writing doesn't need the written appointment to be proved. Proof that he has acted as such an officer is sufficient, and wills that have been admitted to probate in India. But look at explanation 3. It's an important clarification. It says, a statement of fact in a document which is separate from the terms of the contract can be proved by oral evidence.
The illustration in the Act explains this really well.
It does. A gives B a receipt for money paid by B. Oral evidence is offered of the payment. The illustration says this evidence is admissible. Why? Because the receipt is not the contract itself. It's a factual acknowledgement of a payment. The fact of payment can be disputed orally even if a receipt exists. You could argue the receipt was given by mistake, for example.
Okay, that's a lot of ground we've covered. Let's try to summarize this with the hierarchy of proof pyramid visual from the slides.
It's a great way to visualize it. At the very base of the pyramid, you have oral evidence from sections 54 and 55. It must be direct perception. One level up, you have documentary evidence from section 56, which is considered superior to oral evidence. At the top of that, you have primary evidence from section 57. This is the document itself, or its modern digital equivalent, the best of the best. And at the very peak of the pyramid, you have the exclusionary rule of section 94, which says the document at the top trumps the oral evidence at the bottom. And weaving through all these levels now is electronic evidence, which has its own special gateway, the mandatory certificate from section 63.4.
As Satendra Sir says on the final slide, master the sections, review the case laws, write the answer. Before we go, that provocative thought from the outline is really sticking with me. With the new 5-year digital presumption versus the old 30-year paper presumption, is the law implicitly admitting that digital memory is actually more fragile than paper?
It's a fascinating question, isn't it? It touches on the digital dark ages problem that archivists talk about. Paper, if stored correctly, lasts for centuries. But digital files suffer from link rot, format obsolescence, corrupted drives, lost passwords. The law seems to be making a pragmatic judgment. It realizes that in 30 years, we might not even have the technology to read today's electronic evidence. So maybe 5 years is the new window of digital certainty, something for everyone to ponder.
A fascinating thought to leave us with. Thank you for joining this deep dive into the BSA.
Okay.
A crucial topic and a fantastic breakdown. Keep studying.
Precision in law leads to perfection in judgment. Goodbye. Let's understand the next point from here.
Yes, let's. And a very warm welcome to all the students and listeners joining us for this session. We're going to be doing a really focused, deep analysis of some very technical, but also very high-scoring areas of the new law.
Absolutely. And when we say specialized, we really mean it. We are diving deep into the Bharatiya Saksha Adhiniyam 2023. The BSA, this isn't just a surface-level glance.
No, not at all.
Yeah.
This is a structured, you could say masterclass level breakdown. It's designed for serious judiciary aspirants. And we're basing this entire discussion on the excellent source materials provided by the faculty at Target for IQ.
All developed, of course, under the guidance and mentorship of Satendra Sir.
Correct. So today we're targeting the serious student. We're looking at 2 absolutely critical chapters. First, we have Chapter 6, which deals with the exclusion of oral evidence by documentary evidence.
And after that.
And then we tackle Chapter 7, which is all about the burden of proof. We're going to be covering sections 93 all the way through to 104.
Right. And these sections, they're the ones that can really, trip people up in the exam hall, aren't they?
They absolutely are. These are what we call high-yield areas.
Yeah.
If you're preparing for your prelims, you are going to see direct MCQs from these sections. There's no doubt about it.
And for mains?
For mains, you'll get those tricky problem-based questions, all based on the illustrations and concepts we're about to discuss. So, having crystal clear clarity here, well, it's non-negotiable for success.
Fantastic. So we have the slide deck from Satendra Sir right here in front of us. Let's go through this slide by slide and really try to visualize these concepts as we go. Let's jump straight into slide 1.
Right. So looking at this first title slide, the visual is quite powerful. You see the book itself, the Rajasthan Judiciary 2023, and in the background, there's a gavel and the classic scales of justice.
It definitely sets an authoritative tone. The title is clear: Exclusion of Oral Evidence by Documentary Evidence and Burden of Proof. And the scope is laid out right underneath. Bharatiya Saksha Adhiniyam 2023, Chapter 6 and 7, Sections 93-104.
And that visual, it isn't just for decoration. The book itself, that represents the codified written law. The gavel signifies the finality of a court's decision. But what I want you to focus on is the focus box on the slide.
It says, Focus, the supremacy of documents. That sounds quite dramatic.
It is dramatic, and it's meant to be. It's the absolute foundational principle of, well, most of civil law. It means that in the eyes of the law, the written word is king.
The written word is king.
Exactly. If you and I have a dispute, and we've taken the time to write our agreement down on paper, that document reigns supreme. It's considered superior to anything you or I might remember or say about it later. The law trusts the permanence of writing over the, let's say, the slipperiness of human memory.
So if it's written down, the writing wins.
That's the philosophy of Chapter 6 in a nutshell.
There's also a pretty prominent warning box here. It says, avoid confusion with old Evidence Act sections.
This is so crucial for our students, especially those at target for IQ who may have studied the old act before. For more than a century, lawyers in India memorized the 1872 Act. Sections 91 and 92 were the Bible for this topic.
And now that's all changed?
Completely. The geography has shifted. Under the BSA, we're now dealing with sections 93 to 104. You literally have to rewire that legal muscle memory. You can't quote section 91 in your mains answer anymore. You have to know the new numbering. It's a small detail that shows the examiner you're up to date.
Good point. A footer is a nice reminder that this material is from Target for IQ, with Satendra Sir as the mentor and teacher. So let's move forward.
Absolutely. Let's understand the next point from here and move to slide 2.
Okay, we are now officially in Chapter 6. The visual here is really telling. It's the scales of justice, but they aren't balanced at all. On one side, weighing it way down, is a scroll marked documentary evidence.
And on the other side?
On the other side, floating high up in the air, looking almost weightless, is a little speech bubble that says oral evidence.
That single image is the best evidence rule, visualized perfectly. The core concept is simple. When a document exists, that document itself is the primary, the best proof. You can't just come to court and talk about a contract if the actual contract is available. The paper weighs more.
The slide quotes the statute directly. It says, when the terms of a contract have been reduced to the form of a document, no evidence shall be given in proof except the document itself.
Reduced to the form of a document. That's the trigger phrase. The moment you write it down, the door to oral evidence about its terms begins to close. The logic is that writing is a deliberate act. When parties sit down to draft a contract, they are careful. They choose their words. Speech, on the other hand,
it's fleeting.
It's fleeting. It can be misheard, misremembered, or even fabricated. So the BSA, like the old act, says, show me the paper.
The key concept box here uses a math symbol. It reads, general rule, documentary evidence, oral evidence, greater than.
Simple math, but it's legally binding. But, and this is important, look at the trap box. It warns us. TRIAA applies to contracts, grants, and dispositions of property.
Okay, so why is that a trap? What's the pitfall here?
The trap is that students often overgeneralize this rule. They think it applies to everything in life. It doesn't. If I witness a car accident, my oral testimony is perfectly valid evidence. I don't need a document.
Ah, okay.
But if I'm creating or transferring illegal right-selling land, making a formal grant, signing a business contract, and I put that in writing, that's when this rule kicks in. It's for specific legal transactions.
I see. And the exam alert just notes the range for us. Covers sections 94 to 103 of DSA 2023. Good to have that framework.
Precisely. Now let's understand the next point from here and take a look at slide 3.
All right, this is section 93. The visual is pretty modern. It's a folder icon with a big lock on it, and next to it, a calendar page marked 5 years.
This is a huge update for our digital world. Section 93 is titled Presumption as to Electronic Records. This is something every modern lawyer and judge needs to know inside and out.
The text on the slide reads, where any electronic record purporting or proved to be 5 years old is produced from any custody which the court considers proper, the court may presume that the electronic signature was so affixed by him.
Okay, let's break that down using the flowchart on the slide. It shows a clear progression. Old law, S90A of Act 1 of 1872, which points to the new key number, 5 years, which then points to the new law, BSA 2023. Section 93.
Now, wait a minute. I seem to remember the rule for ancient documents in the old law being something like 30 years, wasn't it?
You are absolutely spot on. Under the old Section 90, for physical paper documents, the period was 30 years. If you produced a deed from 1990, the court would generally presume it was genuine.
So why only 5 years for electronic records?
Because technology moves infinitely faster than paper ages. 5 years in the digital world is an eternity. File formats become obsolete, servers are decommissioned, data can degrade. So the BSA introduces this specific, much shorter timeline for electronic records. The new magic number you have to remember is 5 years.
So if I have a digitally signed PDF from 6 years ago, the court treats it with the same kind of presumptive reverence it used to give a dusty 30-year-old manuscript.
In a way, yes, but, and this is a critical distinction, look at the key concept box. It says, court may presume, discretionary.
May not shall.
Vitally important. The court is not bound to believe it's genuine. May presume gives the judge discretion. The judge can look at it and say, okay, this seems legitimate. Or they can say, something about this doesn't feel right. I want you to prove it further. It's not an automatic pass.
And the trap box is practically screaming at us here. Do not confuse with Section 90, ancient documents 30 years.
That is precisely where an examiner will try to catch you. They'll frame a question about an ancient document in general, and your mind might jump to the new 5 years rule. But Section 93 is only for electronic records. For physical documents, the old timelines still apply under the new Act's corresponding section. You can't mix up the physical and digital worlds.
Okay, that's a crucial point. The examiner also says, proper custody is the essential element. What does proper custody even mean for a digital file? It's not like a scroll you keep in a safe.
That's a great question. It means the file is located where you would naturally and reasonably expect to find it. If it's a company's financial record, it should be on the company's secure server or in its official cloud storage. If it's a person's will, it might be on their personal computer or a backup drive they gave to their lawyer.
So if I find a random USB stick on a park bench with a file on it...
That is the definition of improper custody. The chain of possession, the digital trail, it all matters.
That makes perfect sense. All right, let's understand the next point from here. Slide 4.
We are now at Section 94. This is the real bedrock of the chapter. The heading is Evidence of Terms of Contracts, Grants, etc.
The visual here is very clear. It's a big scroll labeled Contract, and it has a huge red stamp on it that says Final. Next to it, there's a silhouette of a person trying to speak, but they're basically being ignored.
That visual perfectly captures what's called the exclusivity rule. Once that final stamp is notionally on the written contract, the speaking stops. The document itself becomes the exclusive source of its terms.
The slide lists 3 bullet points for when this applies.
Terms of contract, grant, or disposition of property.
Reduced to form of a document. And number 3, or required by law to be reduced to document.
That third point is very important. Sometimes you don't have a choice. The law compels you to write it down. For example, a sale of immovable property over a certain value. The law demands a written, registered deed. In those cases, Section 94 applies automatically.
The legal rule on the slide is quite direct. No evidence shall be given in proof of the terms except the document itself or secondary evidence, admissible under the provisions herein before contained.
Notice that little escape hatch for secondary evidence. The law isn't totally rigid. If your original contract was genuinely lost or destroyed in a fire, you're not left without a remedy. You can introduce secondary evidence, like a certified copy or a photocopy.
But there are strict conditions for that.
Very strict conditions. You can't just say, oh, I lost it and start talking. You have to prove the loss first. The main point is the document, either primary or secondary, remains the exclusive proof.
Now, the trap box here points at a very fine distinction. It says, trap. Oral evidence of contents is barred, not existence.
This is a classic lawyer's distinction, but it's critical for exams. You are allowed to orally testify. Yes, a contract exists between me and that person. You are proving the existence of a legal relationship. But you are not allowed to orally testify. And the terms of that contract say the price was 500 rupees. That is proving the contents. Section 94 bars you from orally describing the contents. The document must speak for itself about what's inside it.
So, to put it simply, I can say, we signed a deal, but to prove what the deal was, I have to show the paper.
You've nailed it. That's the exact distinction.
The examiner points to illustration B, bill of exchange, must be proved.
Yes, that's an illustration taken straight from the Bear Act. Examiners love to turn illustrations into MCQs. It's a classic example. If your claim is based on a bill of exchange, you must produce the bill. As we always teach at Target for IQ, knowing the key illustration is like getting a cheat sheet for the exam.
Good to know. Okay, moving on. Let's understand the next point from here. Slide 5.
We're still in Section 94, but now we're looking at the exceptions and explanations. And as we constantly emphasize in our judiciary classes at Target for IQ, understanding the exceptions is the key to clearing prelims. The general rule is easy. The exceptions are where the real marks are.
The visual on this slide is a tree diagram, branching out to Exception 1, Exception 2, and Explanation 3. Let's start with Exception 1, Public Officer.
The text here says, appointment required by law. Acting as such is sufficient proof. No writing needed.
What does that mean in a practical sense?
Imagine the chaos. If every time a judge, a police inspector, or a government official had to testify in court, they first had to produce their original gazetted appointment letter signed by the president or the governor, the system would grind to a halt.
Right, it would be impossible.
So the law creates a very pragmatic exception. If a person is acting as such, if they are sitting in the judge's chair, wearing the uniform, signing the orders, that conduct is sufficient proof of their appointment for the purposes of evidence. We don't need to see the paperwork. As the key concept box says, acting as public officer prima facie proof.
That makes a lot of sense. Okay, Exception 2 is about wills. The text reads, admitted to probate, proved by the probate.
A will is a very special kind of document. After a person passes away, their will often goes through a formal court process called probate. This is where the court officially certifies that the will is valid.
So the probate is like a court seal of approval?
Exactly. And once that probate is granted, the probate certificate itself becomes the ultimate proof of the will. In any future legal proceeding, you prove the contents of the will by showing the probate. It's considered conclusive proof of the will's validity.
And then we have Explanation 3. The text says, facts other than terms of contract, oral evidence allowed. And it points us to an illustration.
Yes, this is the famous receipt exception. Let's look at the illustration.
It says, A gives B receipt for money. Oral evidence offered of payment. Admissible.
This is a very common trick question.
Yeah.
Here's the logic you must understand. A receipt is not the contract itself. A receipt is just a document acknowledging a fact, the fact that payment was made.
It's just a record of an event.
Precisely. It's not defining the rights and obligations of the parties like a contract does. So even if I give you a written receipt that says received 1,000 rupees, you are perfectly entitled to come to court and give oral evidence saying, actually, the payment was for 2,000 rupees and he wrote the receipt incorrectly.
Why is that allowed?
Because you're not trying to vary the terms of a contract. You are simply disputing a fact that happens to be recorded on a piece of paper. You can challenge facts orally. You just can't challenge the terms of a formal contract orally. It's a very fine but very important line.
I see it now. The receipt isn't the deal. It's just evidence of one part of the deal happening.
You've got it. The distinction is tested very often.
All right, let's understand the next point from here. Slide 6.
We're now moving to Section 95. This is really the other side of the Section 94 coin. If Section 94 says you must bring the document, then Section 95 says, and you cannot bring oral evidence to mess with that document.
The visual here is very striking. It's a huge golden shield labeled Section 95, and there are 4 arrows bouncing harmlessly off it. The arrows are labeled contradict, vary, add to, and subtract from.
I really like this visual because it perfectly shows the protective function of this section. Section 95 is the shield that defends the integrity of a written document from oral attacks.
The core rule on the slide reads, "No evidence of any oral agreement or statement shall be admitted as between the parties, for the purpose of contradicting, varying, adding to, or subtracting from its terms."
Those 4 verbs are the key. Contradict, vary, add, subtract. You should memorize them. Let's call it the CVAS rule. If our written contract says the price is 100, you can't bring a witness to say, but they orally agreed the price was 120. That would be varying the term.
So you can't say, "We also orally agreed he would wash the car every week."
Correct. That would be adding to its terms. The written document is considered complete and final. It binds the parties who signed it.
And that's a key point on the slide. Applies between parties to such instrument or their representatives.
Yes, this is a crucial limitation. It applies to us if we are the ones who signed the contract. It does not apply to a third party, a stranger to the contract, as the key concept box points out. Applies only to parties. See S102 for strangers.
So if I signed a lease that clearly says no pets allowed, I can't later bring my friend to court to testify. Oh, but the landlord told her orally that small dogs were okay.
That is a perfect example. The document says no pets. You signed it. Section 95 acts as a shield, deflecting your attempt to orally vary or contradict that term. The judge will look at the lease and say, objection sustained, evidence excluded. The written word stands.
But there must be some situations where this rule is too harsh. What if there was fraud? Or what if we made a completely separate side deal?
Now you're thinking like a lawyer, and the law has already thought of that. Section 95 is a strong shield, but it's not impenetrable. It has gateways, it has provisos. And that brings us to our next slide.
Okay, let's look at those gateways. Let's understand the next point from here on slide 7.
So the visual here is a brick wall symbolizing the rule, but it has 2 open doors cut into it. These are our gateways or provisos.
Door 1 corresponds to proviso 1. The label on it is invalidating facts.
And inside that door, you see a list of very serious issues. Fraud, intimidation, illegality, want of due execution, mistake.
So this is about attacking the very foundation of the contract.
Exactly. There's a famous legal maxim. Fraud dissolves all solemnity. If you can prove that I tricked you into signing the document or held a gun to your head or that the contract was for an illegal purpose, then Section 95 will not stop you. You can give oral evidence to prove that fraud or intimidation.
Because you're not trying to change a term. You're trying to prove the whole contract is void.
Precisely. You're saying the foundation is rotten, so the entire building should be condemned. The exam alert also mentions want of failure of consideration falls under this. If I promised to pay you for something and never did, you can prove that failure orally.
Okay, that makes sense. Now for door 2, which is proviso 2, the label is separate oral agreement, and there's a little flowchart inside that says matter on which doc is silent, not inconsistent with its terms.
This is for all the things we might have agreed upon but just didn't write down.
Yeah.
Let's say we have a written contract for the sale of a car. The contract is detailed, but it says absolutely nothing about when or where the car keys will be handed over. It's completely silent on that matter.
Okay.
We can have a separate oral agreement that says, I'll drop off the keys at your office on Friday. I can give evidence of that oral agreement because it doesn't contradict anything in the written contract. It just fills in a silent gap.
But the trap box has a big warning. Trade or pay, proviso 2. Document must be silent on the matter.
This is the catch. If our written car contract explicitly said keys to be delivered to buyer's home on Saturday, then you cannot use proviso 2 to claim we had an oral deal to deliver them on Friday. That would be inconsistent. This proviso only works for true, genuine gaps.
There's also some tiny text there. Court considers degree of formality.
Yes. The more formal and detailed the document is, the less likely a court is to believe that the parties left important things to a separate oral agreement. If it's a 50-page deal drafted by lawyers, the court will assume everything important was written down.
Okay, let's move to slide 8. 3 more doors.
Yes, continuing with the provisos of Section 95.
Door 3, proviso 3, is labeled condition precedent. And the text inside says, obligation hasn't attached yet.
This is what we often call the escrow proviso. It's for a situation where we sign a contract today, but we orally agree that the contract will only become active if some future event happens.
Can you give an example?
Sure. We sign a contract for me to buy your house, but we orally agree this contract is only binding if I get my home loan approved by the bank within 30 days. That approval is a condition precedent. Even though we've both signed, our legal obligations haven't attached yet. I can give oral evidence of that condition.
Okay, I get it. Door 4, Proviso 4, is for subsequent modification. It reads, distinct oral agreement to rescind modify.
This one is just common sense. We sign a written contract on a Monday. Can we meet for coffee on Tuesday and mutually agree to change some of its terms? Of course we can. We can make a new, distinct oral agreement to modify or even completely cancel the old written one.
But wait, there's a big red warning box attached to this door. It says, not if law requires writing registration.
This is the crucial trap. This is a classic mains question. If the original contract was one that the law required to be in writing and registered, like a sale deed for land, then you cannot modify it orally.
So you can't just shake hands to change the boundary line of a registered property deed?
You absolutely cannot. To modify a registered deed, you generally need another registered document. The formality required to create the right is the same formality required to change it. This is a very important exception to the exception.
Got it. And finally, Door 5, Proviso 5, is about usage or custom. It says, incidents usually annexed.
This is about unwritten rules of a particular trade or locality. If you are in the diamond trade in Surat or the tea trade in Assam, there are certain customs and usages that everyone in that business understands and follows, even if they aren't written down in every single contract.
Like who pays for insurance during shipping, for example.
Exactly. The court allows you to bring oral evidence to prove that such a custom exists and should be read into the contract. But there's a condition.
Let me guess. It can't contradict the written terms.
You're one step ahead. The exam alert says, custom must not be repugnant to terms. Repugnant just means contradictory. If the contract explicitly says buyer pays for insurance, you can't bring evidence of a custom that says seller usually pays. The express written term will always override the implied custom.
Okay, that makes sense. Let's understand the next point from here. Slide 9.
We're just finishing up Section 95 now with its final part, Proviso 6, and then some important case law. The visual is a magnifying glass hovering over an old handwritten letter, suggesting a close examination of language.
The text for Proviso 6 reads, any fact may be proved which shows in what manner the language of a document is related to existing facts.
This is what I call the context proviso. Words on a page don't exist in a vacuum. They relate to the real world. This proviso allows you to bring in evidence of surrounding circumstances to show how the language of the document connects to the actual facts on the ground.
But the case law analysis section seems to suggest there are limits to this. The first case is Mangalawaman Karandikar v. Prakash Damodar Ranade, 2021.
Yes, this is a very important and relatively recent Supreme Court ruling. The court issued a warning saying, look, Proviso 6 is meant to provide context, not to be a backdoor for contradicting the document. If the text of the document is clear and unambiguous on its own, you cannot use the excuse of surrounding circumstances to try and twist its meaning.
So context is allowed, but not contradiction.
That's the key takeaway. Proviso 6 cannot be used to override the main rule of Section 95. If the words are plain, they mean what they say.
And the second case, Anglo-American Metallurgical Coal Putty Ltd v. MMTC Ltd. This one says the entirety of correspondence must be read.
Right. This means you can't just cherry pick one email or one sentence that suits your case. To understand the context properly, the court must look at the whole picture, the entire chain of communication that led to the final document. As we always advise for mains answers, citing a recent case like Mangalawaman shows the examiner you are well read and can earn you those extra marks.
Great tip. Okay, let's understand the next point from here. Slide 10.
Now we're moving into the fascinating area of ambiguous documents. We're starting with Section 96. And under the guidance of Satendra Sir, we always emphasize that spotting the difference between patent and latent ambiguity is a guaranteed question area.
The visual here is a scroll with a huge red question mark on it, and the text on the scroll itself is confusing. It says, price RS1000 or RS1500.
That is the perfect example of what the law calls a patent ambiguity. Patent means it's obvious, it's right there on the face of the document. You don't need any outside information to be confused. You just read it and you immediately think, wait, what?
The heading is Section 96, ambiguous or defective documents. And the rule here seems very strict. It says, when language is, on its face, ambiguous or defective, evidence may not be given of facts which would show its meaning or supply its defects.
Don't that phrase, may not. It is an absolute strict prohibition. The law's attitude is, you had one job to write a clear document. You failed. We are not going to help you fix your mess.
So the illustration on the slide, A, says, A agrees to sell horse for 1 lakh rupees or 1,50,000 rupees. Evidence cannot be given.
Exactly. Which price is it? The document doesn't say. It's defective on its face. The court will not allow the parties to bring witnesses to testify, oh, what we really meant was 1,50,000. No, it's too late. The contract is considered void for uncertainty.
And what about illustration B? A deed contains blanks. Evidence cannot be given to fill them.
This is the classic blank space rule. If you draft a deed and you leave a critical part blank, like the name of the person receiving the property or the property number itself, you cannot come to court later and try to fill in those blanks with oral testimony. The document is patently defective. It's a legal nullity.
So the bottom line for patent ambiguity is, if the problem is obvious on the page, no external evidence is allowed to fix it.
You've got it. The document fails on its own terms.
All right, let's understand the next point from here. Slide 11.
Now, we need to contrast that immediately with Section 97. Look at the visual here. It's two puzzle pieces. One is labeled document, and the other is reality, and they fit together perfectly.
The heading is Section 97, Application to Existing Facts. The core concept is language plain in itself plus applies accurately to existing facts.
So Section 97 is the complete opposite of ambiguity. This is the ideal scenario where everything is crystal clear, the document is clear, and it perfectly matches the situation in the real world.
And the rule here is, evidence may not be given to show it was not meant to apply to such facts.
This is what I call the no-takebacks rule. If the puzzle pieces fit perfectly, you are not allowed to come to court and argue that you were actually trying to solve a different puzzle.
The illustration really clarifies this. It reads, S sells my estate at Rampur containing 100 bighas. A has an estate at Rampur of 100 bighas. Evidence cannot be given that he meant a different estate.
Exactly. A Keiki can't come to court and say, yes, I know the deed says Rampur, and yes, I do own an estate in Rampur that matches the description. But you see, in my heart, I was really thinking of my other estate in Jaunpur.
The court would just laugh that out.
The court would say, sorry, the words are plain. They fit the facts. Case closed. You cannot bring oral evidence to contradict a plain meaning that fits the reality perfectly.
Okay, that's clear. Now let's move to slide 12. This is Section 98. The visual is a map showing two nearby places, Kolkata and Howrah.
Right, so if Section 97 was about a perfect fit, Section 98 is about a complete misfit. It's where the language of the document is plain, but it's meaningless when you apply it to reality.
The heading says, Section 98, unmeaning in reference to existing facts, and the illustration is key. Deed says, my house in Kolkata. Ad has no house in Kolkata, but has one at Howrah. Evidence admissible to prove the deed related to Howrah.
You see the critical difference from the last section. In the Rampur example, the man had land in Rampur. The description fit. Here the deed says Kolkata, but the man has no house in Kolkata. The description, when applied to the facts, points to nothing. It's meaningless.
So because it's meaningless otherwise, the court allows evidence to fix it.
Exactly. It's clear that a mistake in description has been made. He obviously meant his house in Howrah, which is right next to Kolkata. If the court doesn't allow evidence to clarify this, the deed becomes totally useless. So Section 98 opens the door for evidence to correct a clear misdescription.
Okay, so just to recap, Section 96, patent ambiguity on the page, no evidence. Section 97, perfect fit with reality, no evidence. Section 98, total misfit with reality, evidence is allowed.
That is a perfect summary of the distinction.
Great. Let's understand the next point from here. Slide 13.
This brings us to the other type of ambiguity. We're looking at Sections 99 and 100, which deal with equivocation, or what we call latent ambiguity.
And the visual is quite famous in law schools, I believe. It's two identical white horses.
The classic example. Latent means hidden. This is an ambiguity that is not obvious on the face of the document. The problem is hidden until you look at the external facts.
So Section 99's concept is, language applies to one only of several person things, and the illustration is exactly what we see. A has two white horses, evidence admissible to show which one.
Okay, let's play this out. Imagine a written contract that says, I, A, agree to sell my white horse to B for 50,000 rupees. You read that document. Is there anything confusing or ambiguous on the page itself?
No, it looks perfectly clear.
Exactly, no patent ambiguity. But then we go to A's stable to collect the horse, and we open the door and see two identical white horses standing there. Suddenly, a problem arises. An ambiguity is revealed, not from the words, but from the facts. That is latent ambiguity.
And so evidence is allowed to clarify which horse was meant?
Yes. B can bring a witness to say, we were looking at the horse on the left when we made the deal. That evidence is admissible to resolve the hidden confusion.
And Section 100 seems similar. The concept is language applies partly to one set of facts, partly to another. The visual shows land at X and land at Y.
This is for a mix-up description. For example, the deed says, I sell my land at X in the occupation of Y. But the reality is that I own land at X, but it's occupied by Z. And I also own land at a different place, W, which is occupied by Y. The description is partly right and partly wrong for two different properties.
So again, evidence is needed to sort out the mess.
Correct. Section 100 allows evidence to show which piece of land was actually intended to be sold. So the main takeaway, as the trap box says, is that in cases of latent, hidden ambiguity, evidence allowed in both cases to clear confusion. That's the direct opposite of the rule for patent ambiguity.
Got it. Let's understand the next point from here. Slide 14.
Okay, this is Section 101. The heading is Illegible Characters and Technical Terms.
The visual is a scroll with some very strange, unreadable text on it, and there's a magnifying glass over it which says, evidence is admissible to show meaning. There's also a little icon of a sculptor at work.
This is what I like to call the translator section. Sometimes the problem isn't ambiguity in the legal sense. The problem is that the court just doesn't understand the language or symbols being used.
The slide lists several examples. Illegible or not commonly intelligible characters, foreign, obsolete, technical, local expressions, abbreviations, and words used in a peculiar sense.
Right. So if a contract is written in, say, an old form of shorthand, or it uses highly technical jargon from a specific industry, or it's in a local dialect, the court needs help. Section 101 allows a party to bring in an expert witness, a translator, an industry expert, to explain what those terms mean.
And the illustration of the sculptor fits right in here. A sculptor agrees to sell all my mods, evidence admissible to show he meant models.
Exactly. To you or me, mods might mean modifications or something else. But in the sculpting world, it's common slang for models. Section 101 allows the sculptor to bring evidence to prove that peculiar technical meaning of the word.
The exam alert reminds us to remember mods, models, and importantly, don't confuse with S96.
That's a good point. Section 96 is for a document that is perfectly fine, but just needs to be deciphered or translated for the court.
Okay, that's clear. Moving to slide 15, and this is section 102.
The big question here is, who may give evidence varying terms?
The visual is interesting. It shows two people, A and B, shaking hands like they've made a deal. And then there's a third person, C, standing off to the side, who the slide labels as a stranger third party.
This section is a direct callback to Section 95. Remember how we stressed that Section 95, the shield, binds the parties to the contract? Well, Section 102 is the flip side. It's about freedom for the strangers.
So the rule is, persons who are not parties to a document, or their representatives, may give evidence of facts tending to show a contemporaneous agreement varying the terms.
Let's break that down. A and B sign a written contract. Between themselves, they are bound by it.
Yeah.
Section 95 locks them in. But what about C? C didn't sign it? C is not part of their private supremacy of documents pact.
So C isn't bound by their piece of paper.
Not at all. So if that contract between A and B somehow affects C's legal interests, C can walk into court and say, Your Honor, I know what their paper says, but I have evidence that they had a completely different oral agreement on the side, and that oral deal is what affects me.
And C is allowed to do that.
Yes. The illustration makes it plain. A and B make a written contract. C, stranger, can show A and B had a different oral agreement if it affects C's interests. The crucial trap here, though, is that a party to the contract A or B cannot use Section 102 as a weapon. If you sign the document, you're bound by Section 95. Only the outsider, the stranger, gets to use Section 102.
Got it. Let's understand the next point from here. Slide 16.
This is Section 103, Savings. As Satendra Sir always reminds us, you should always check the savings clause in any chapter to see what other laws might override the one you're reading.
The visual is a safe or a vault, and inside it is a scroll labeled Will. The text reads, Nothing in this chapter shall be taken to affect any of the provisions of the Indian Succession Act 1925 as to the construction of wills.
This is a very simple but important legal principle. The rule is, special law prevails over general law.
And in this case?
In this case, the Bharatiya Saksha Adhiniyam is a general law of evidence. The Indian Succession Act, however, is a special law that deals specifically with wills. So, if there's ever a conflict between a rule in this chapter of the BSA and a specific rule in the Succession Act about how to interpret a will, the Succession Act wins.
So the Succession Act is the boss when it comes to wills.
It is the boss. The trap box notes, Strict BSA rules do not override will construction rules. This often comes up as a true or false statement in prelims exams, so it's good to be clear on it.
Good to know. Okay, let's understand the next point from here. And it looks like we are shifting gears completely. Slide 17.
Yes, we are. We're now leaving the entire documents versus oral evidence debate behind. We're entering Part 4 of the Act and Chapter 7, which is all about the burden of proof.
The visual is the large golden scales of justice again, but this time the focus is on a question written below it. Who has the duty to prove a fact?
And that's the central question of this chapter. In a court case, facts don't just magically appear and prove themselves. Somebody has to do the hard work of presenting evidence. This chapter tells us who has that job. The trap box on this slide explains the concept beautifully. Rules determine who loses if no evidence is given.
That's a fascinating way to think about it. The burden isn't just about who has to work to win, it's about who loses by default if everyone just stays silent.
Precisely. If at the end of the day the judge looks at the file and there's absolutely zero evidence on a particular point, the person who had the burden to prove that point automatically loses.
Okay, let's see how that works. Slide 18. This is the foundational section, section 104. The visual is powerful. It's a silhouette of a man pushing a massive, heavy boulder up a steep hill.
That boulder is the burden of proof. It's heavy, it's difficult, it's work.
The heading is Section 104, Burden of Proof, and the text says, whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts, must prove that those facts exist.
This is the embodiment of the Latin maxim onus probandi. The burden of proving lies on the person who asserts a fact. In simple terms, if you want the court to do something for you, if you desire judgment, then you have to prove the facts that entitle you to that judgment. You can't just make an assertion and then sit back and expect the other person to disprove it.
The illustrations make this very practical. A says, A desires court to punish B for a crime. A must prove B committed the crime.
This is the absolute bedrock of our criminal justice system. The prosecution, A, wants the court to punish B. Therefore, it is the prosecution's job to push that heavy boulder up the hill. They must prove guilt beyond a reasonable doubt. The accused, B, doesn't have to prove their innocence. B can just stand at the bottom of the hill. If A fails to get that boulder all the way to the top, B goes free.
And it's the same in civil cases. Illustration Baz says, A desires judgment for land which is in the possession of B. A must prove his own entitlement to the land.
Same principle. If I file a case to get your land, the burden is on me to prove it's my land. I can't just file a case and say to you, hey, prove that the land is yours. No, I'm the one who started the case. I'm the one desiring judgment, so I carry the burden.
The trap box adds another layer. If A asserts and denies nothing, A must still prove his assertion.
Meaning, even if the other side doesn't show up to court or stays completely silent, you don't win automatically. You still have to present enough evidence to the judge to satisfy your burden of proof. You win because you proved your case, not just because the other side was quiet.
That's a key point. Let's understand the next point from here. Slide 19.
This slide is titled Analysis, Burden of Proof and Presumptions. The visual shows a gavel, representing law, and a microscope, representing scientific analysis and truth.
We have three important case laws listed here. The first one is Uniworth Textiles, LTDV CCE 2013. Burden of proving mala fides lies on the shoulders of the one who is alleging it.
Mala fides is a legal term for bad faith or dishonest intention. It is a very serious allegation to make against someone. So the Supreme Court has repeatedly held that if you are the one accusing a person or an authority of acting in bad faith, the burden is entirely on you to prove it with strong evidence. It's not something the court will just assume.
Okay. The second case is Nandlal Wasudeo Badwaik Vilatan Nandal Badwaik 2014. This one has a powerful quote. When the truth or fact is known, there is no need or room for any presumption.
This is the landmark DNA case. In family law, there is a very strong legal presumption that a child born during a valid marriage is the biological child of the husband. It's a presumption to protect the child.
Right.
But in this case, a DNA test conclusively proved that the husband was not the biological father. So the question was, what wins? The legal presumption or the scientific truth? The Supreme Court held that scientific truth is paramount. When you have conclusive proof of a fact, like a DNA report, it completely overrides any legal presumption to the contrary. As the slide says, truth presumption. When you have the microscope of science, you don't need the blindfold of presumption.
That's a very powerful principle. The exam alert here strongly recommends to memorize Nandal-Badwake principle for mains.
It's a must-cite case. It's a goldmine for marks on any question about evidence and presumptions.
And the final case is Offshore Holdings, P. Ltd v. BDA, 2011. One who questions the constitutional validity of a law takes the onus of proving it.
This is about the presumption of constitutionality. Courts start with the assumption that laws passed by the legislature are valid. So if you are the one challenging a law and claiming it's unconstitutional, the burden is on you to prove why.
That makes sense. Okay, let's understand the next point from here. Our final slide, slide 20, the master summary.
Yes, this has a clipboard with a quick revision flowchart. Let's run through it quickly to bring everything together.
Okay. Step 1. Doc exists. China's S-94. Doc is exclusive proof.
The starting point. If there's a document, it's king.
Step 2. Want to vary it? S-95. Stop. Only if provisos apply.
The shield is up. You can't touch the document unless you have a key to one of the proviso gateways.
Step 3. Ambiguity on face. S-96 patent. No evidence.
If the document is nonsense on its face, the court won't fix it. It's dead.
Step 4. Ambiguity in context. S-979899. Latent evidence allowed.
If the problem is hidden and only appears when you look at the facts, the court allows evidence to solve the puzzle.
And finally, step 5. Who proves? S-104, he who asserts.
The fundamental rule of burden of proof. If you want something, you have to prove it.
That's a fantastic, concise roadmap of everything we've covered, and there's a closing quote on the slide.
Yes, from Satendra Sir. Success in judiciary comes from precision, not just knowledge. And that's really the theme of this entire chapter. Knowing the fine distinctions is what separates the top rankers from the rest.
This has been an incredibly detailed look at sections 93 through 104 of the BSA 2023, a dense but, as you said, absolutely critical area of the law.
Indeed. My final advice is to keep revising the difference between patent and latent ambiguity, and know those Section 95 provisos by heart. Keep studying hard, and for more detailed classes like this, you can always join us at Target for IQ under the guidance of Satendra Sir.
Thank you so much for that brilliant breakdown, and thank you all for listening. Jai Hind.
Jai Hind, and all the very best for your preparation.
Okay, let's understand the next point from here. We are back with another deep dive, and today we're doing something a little different. Usually we look at a book or maybe an article, but today we are looking at, well, the rule book of reality itself, or at least the reality that gets accepted inside a courtroom.
That's a very dramatic way to put it, but, you're not wrong. We are looking at the mechanism of proof, what counts as truth in the eyes of the law.
And we're digging into this massive transition happening in Indian law right now. We're moving from the old colonial era Indian Evidence Act of 1872, I mean, that's been the Bible for lawyers for 150 years, to the new Bharatiya Saksha Adhiniyam 2023. The BSA.
And it is so important to stress this. This isn't just a name change. It's not just renumbering sections. It's a modernization. It's a fundamental renovation of the structure.
Exactly. And to guide us through this, we've got a very specific set of source materials. We're analyzing a comprehensive lecture deck from Target for IQ, which was prepared under the guidance of Satendra Sir. Now, these aren't just general notes. These are designed specifically for judicial services aspirants, people preparing for the PCS-J exams.
Which means our conversation today is going to be, let's say, high stakes. We aren't just discussing legal philosophy in the abstract. We're looking for exam alerts. We're looking for traps for landmark case laws.
And all the specific nuances that a judge or, well, a future judge absolutely needs to know.
Yes.
So if you're listening to this, imagine you're sitting in that exam hall, or even better, on the judge's bench. We're focusing on Part 5 of the BSA, specifically sections 120 to 141.
And this covers two absolute pillars of any trial, estoppel and witnesses.
Who can speak, who can't speak, and who gets stopped from changing their story halfway through.
That's a perfect summary.
All right, let's jump right in. Section 120, presumption as to official acts.
This is our starting point. And it's the right place to start. Imagine a trial has just begun. The prosecutor walks in and tables a huge stack of documents, police reports, seizure memos, records of all these official acts. The very first question the law has to answer is, do we trust this?
I feel like the cultural default, maybe for movies or just, general cynicism, is to say no. We sort of assume the police might have messed up, or the paperwork is sloppy, or even worse, maybe it's fabricated.
That's the popular view, perhaps, but Section 120 establishes the legal view, which is different. The core concept here is that official acts, and this is especially true for those of the police and administration, are presumed to be regularly performed.
Regularly performed. That's a very specific legal phrase. What does it mean in practice?
It means the court assumes, as its baseline, that the proper procedures were followed, that the formalities were observed, that, the I's were dotted and the I's were crossed. It's a presumption of regularity.
Innocence until proven guilty applies to the paperwork, too?
In a way, yes. And this reflects a major shift in judicial attitude that students absolutely need to note down. There's a specific case law cited in our Target for IQ material, Surinder Kumar versus State of Punjab from 2020.
What happened in that case? What was the issue?
Well, the Supreme Court addressed this exact problem of skepticism. The defense was basically arguing that the police investigation was flawed simply because, well, it was a police investigation. It was an argument based on a general distrust.
A sort of you can't trust the cops defense.
Precisely. And the court used very, very strong language. They said, we must discard the archaic notion of initial distrust of the police.
Archaic notion? Wow, that's basically the Supreme Court saying, stop living in the past. This isn't how we operate anymore.
Exactly. It's a clear directive to all the lower courts. You cannot start a trial with the built-in presumption that the system is broken or that the police are inherently untrustworthy. That initial distrust is, in the court's own words, outdated.
But, and this is the important part, I think, does that mean the police are always right? Is it an absolute presumption?
No, and that is the exam alert. It's a rebuttable presumption. The court says, we will assume this is correct unless you prove otherwise. It just shifts the burden of proof.
So it's on the defense then?
It's on you, the defense, to bring specific, concrete evidence that a procedure was violated. You can't just wave your hands and say, I don't trust it. You have to point to the mistake. This form wasn't signed, or this procedure wasn't followed.
Got it. So vague complaints and silence won't work. And speaking of silence, Section 120 also deals with something called an adverse presumption.
Yes, this is the flip side of the coin. We just talked about trusting the officials. Now let's talk about what happens when we can't trust the parties in the suit themselves. The case to remember here is Iqbal Basith versus N. Subbulakshmi.
This sounds like a situation where someone tries to be too clever by staying quiet.
That's exactly it. Imagine you're a defendant in a civil suit. The plaintiff has made some very serious allegations against you. You file a detailed written statement denying everything, point by point, but then the trial starts. Witnesses are called, and when it's your turn to step into the witness box and face cross-examination.
Suddenly you're busy. You have to wash your hair that day.
Precisely. You avoid the stand. You avoid the tough questions. The rule laid down in Iqbal Basith is crystal clear. If a party avoids the witness box and denies the other side the opportunity to cross-examine them, the court is fully entitled to draw an adverse presumption.
Meaning the judge assumes the worst.
It means the judge thinks if you had a truthful explanation, you would be eager to get on that stand and give it. Since you are hiding, I'm going to assume that the truth would have hurt your case. Your silence speaks volumes.
So silence can literally become evidence against you.
In this specific context, absolutely. Now, we need to shift gears within the same section, Section 120, to a matter of extreme gravity. The second part of the section deals with rape prosecution.
I see this in the notes. It says it references the definition of sexual intercourse from Section 63 of the new Bharatiya Nyaya Sanhita 2023.
Yes, the new criminal code, the BNS, works in tandem with the BSA. They're designed to be read together. But the crucial point here is about consent. This is a mandatory presumption that every single judicial aspirant must memorize, because the wording is everything.
Okay, lay it out for us. What's the rule?
In a prosecution for rape, once the sexual act itself is proved, the only question left for the court is, was it consensual? Now look at the woman's testimony. If she states in her evidence before the court that she did not consent.
Okay, so she gets on the stand and says, no, I did not consent.
Then the court shall presume that she did not consent.
You're really emphasizing that word shall.
I am. And as we always teach at Target for IQ, this is for a very good reason. In legal interpretation, there's a massive, massive canyon between the words may presume and shall presume.
May means the judge has a choice, a bit of wiggle room.
May implies discretion. The judge can look at all the surrounding circumstances and decide whether or not to make that presumption. But shall takes that choice away completely. It's a command from the legislature to the judiciary. The judge must start with the legal fact that there was no consent.
Wow, that completely shifts the entire burden of proof onto the accused.
100%. The accused now has the monumental task of proving, with evidence, that there was consent. The default setting of the trial, by law, becomes no consent.
That is a powerful tool for justice and a massive trap for exams if you mix up those two words.
It absolutely is. If you write may presume in your mains exam answer for this question, you will very likely lose the mark for that entire section. It fundamentally changes the legal standard.
Okay, that's crystal clear. Let's move to the next huge pillar. We are now entering the territory of Section 121, the doctrine of estoppel.
Estoppel. This is one of the most fascinating and, I think, elegant concepts in equity law. It comes from a Latin maxim, Alligens contraria non est audiendus.
Okay, let's unpack the Latin for everyone. What does that translate to?
It means a party is not to be heard to allege the contrary.
And in plain English.
You're not allowed to blow hot and cold. You cannot say one thing today to get what you want and then come back tomorrow and say the complete opposite to avoid the consequences of it.
So it's the official legal version of the no takesies backsies rule.
You could call it that, yes. But let's look at the structure, because that's what you need for the exam. Our source material, the target for IQ, deck, breaks this down into three very distinct elements. You can almost see it as a flowchart.
Let's walk through it. What's step one?
Step one is the declaration, act, or omission. One person, let's call him person A, intentionally says something, does something, or even fails to do something. They say, I own this piece of land, or they act in a way that makes you think they own it.
Okay, step two.
Step two is belief. Person A intentionally causes another person, person B, to believe that thing to be true. This isn't just an accidental misstatement. There's an element of intention to make the other person believe.
And step three is the crucial one, I imagine.
This is the kicker, action. Person B acts upon such belief. They don't just believe it and do nothing. They rely on that statement. They buy the land. They sign a lease. They invest money. They change their position in a real way based on what person A said.
And once those three steps have happened, the legal trap snaps shut.
That's the perfect metaphor. The
Yeah.
result is that neither person A or anyone representing them later is allowed to deny the truth of that first statement. Even if person A comes to court and says, look, I have the real property records here. I can prove I didn't own the land. I was lying. The court essentially says, we don't care. For the purposes of this dispute, you are estopped. We will treat you as if you owned it because that's what you made person B believe.
So in that specific moment, the law values fairness and consistency over the actual literal truth.
It values the integrity of the transaction. It's there to prevent fraud and injustice. But here's a deep dive point regarding the nature of this doctrine. Is estoppel a weapon you can use to attack someone?
Right. Can I walk into court and say, I want to sue you for estoppel?
No, you can't. And this is a key distinction. Estoppel is a rule of evidence. It's not a cause of action in itself. It is a shield, not a sword. You use it to stop the other person from making a particular argument. You use it defensively, not to initiate a lawsuit.
The notes mention a case here, B.L. Sridhar versus K.M. Munareddy from 2003.
Yes, that case clarifies two things. First, that estoppel is juris e jure. It's an absolute conclusive presumption of law. But second, and this is important, it's also argumentum ad hominem.
Which means against the man.
Exactly. It applies against that specific party who made the misleading statement. It doesn't bind the whole world. So if I lie to you about owning a car, I am estopped from denying it in our dispute. But if a third person who wasn't part of our deal walks in, they're not bound by my lie. They're free to tell the court the actual truth.
Now let's talk about the exceptions, the traps. When does estoppel fail?
The biggest exam alert, the one every student must know, is the conflict between estoppel and statutes. The rule is simple and absolute. There is no estoppel against a statute.
What does that mean in a real-world scenario?
Let's look at the case of Snegupta versus Devi Sarup from 2009. Imagine there's a law, a statute, that very clearly says it is illegal to sell public park land to private individuals. It's a clear prohibition.
Okay, the law is clear. You can't do it.
Right. Now imagine I'm a con artist.
Mm-hmm.
I come to you and say, hey, I own this public park. I have the authority to sell it. Do you want to buy it? You believe me. You pay me millions. We sign a contract.
So I have acted on your declaration. All three elements of estoppel are there. You should be estopped from denying the sale.
Logically, yes. But here's the twist. Later, when you try to take possession, the government stops you. You sue me. I go to court and say, actually, the sale is void because the law says you can't sell parkland.
Wait. You're the one who lied. The court shouldn't allow you to use your own lie to get out of the deal.
And your gut instinct is right from an equity standpoint, but the law says no. The court cannot enforce an illegality. Your private deal, even one based on my lie, cannot override a public law passed by the legislature. Estoppel cannot be used to force a court to do something that is illegal. The statute always wins.
That's a very harsh rule. It feels like the liar gets away with it.
Well, you can still sue him for fraud or to get your money back under a different law, but you cannot use the doctrine of estoppel to get ownership of the land. The law protects its own integrity, first and foremost.
That is a crucial distinction. The notes also highlight another trap, confusing res judicata with estoppel.
Yes, aspirants mix these up all the time. It's simple when you think of it this way. Res judicata, which is in Section 11 of the Civil Procedure Code, bars the court from rehearing a matter that has already been decided. Estoppel bars a party from saying something different from what they previously said.
So one handcuffs the judge and the other one handcuffs the liar.
That's a perfect way to put it. I love that analogy.
Okay, let's move to specific estoppel. Sections 122 and 123, starting with landlords and tenants.
This is Section 122. It's a very practical, everyday rule. If you are a tenant of immovable property, an apartment, a shop, a house, you cannot deny the title of the landlord who let you into possession.
So I can't rent your house, move in, and then a month later stop paying rent by claiming, hey, you know what, I don't think you actually own this place.
Exactly. By accepting the lease from the landlord, you are accepting their title to grant that lease. But, this is a huge, but Satendra Sir's notes have a warning here, highlighted in bold, regarding the timeline.
I see. It says at the beginning of the tenancy.
Yes. This is the whole nuance of the section. The estoppel applies to the state of things at the beginning. So if I move into your house, and you are the owner, I can't deny that fact. But what if 6 months into my tenancy, you sell the house to someone else? Or the bank forecloses on your mortgage and takes ownership?
The situation has changed after the beginning.
Precisely. In that case, I can deny your title. I can say, look, you were the owner when I moved in, but you aren't the owner anymore, so I'm not paying rent to you. I am not stopped from proving a subsequent loss of your title.
That makes perfect sense. It doesn't lock you into a false reality forever, just regarding the facts at the start of the relationship.
And the very same logic applies in Section 123 to bailees and bills of exchange. If I give you my watch to repair, that's a contract of bailment. You, the bailee, can't later refuse to give it back by saying, I don't think you're the real owner of this watch. You accepted it from me. You have a duty to return it to me.
Unless. There's always an unless.
Unless the true owner shows up. That's the exception. If the police come to your shop and say, that watch is stolen property and we have a report, then you, the bailee, can prove that a third party has a superior right to the property.
Okay, that's a clear framework. Let's shift gears completely now. We've talked about people being stopped from changing their stories. Now let's talk about who gets to tell a story in the first place. This is witness competency, Section 124.
Yes, this is the absolute bedrock of any trial. Who is even allowed in the witness box? The general rule in Section 124 is refreshingly simple and broad. All persons shall be competent to testify.
So the default position is the door is open to everyone.
Absolutely. Competency is the rule. Incompetency is the exception. The BSA doesn't waste time listing who can speak. It gives a very narrow functional test for who cannot.
And how does a judge decide? What is that test?
It's a functional test, not a status-based one. The court looks at the person in front of them and asks two simple questions, and you can visualize this as a flowchart. 1, is this person prevented from understanding the questions being put to them?
Okay, can they comprehend?
And 2, is this person prevented from giving rational answers to those questions?
Can they communicate logically? So if they can understand an answer rationally, they're in.
They're in, regardless of their age, their medical history, or their background. This section does list potential causes for this inability, like tender years for very young children, extreme old age, or disease, whether of body or mind.
Let's talk about that, disease of mind. The source material has a specific lunacy explanation.
This is a point that often trips up students. We have this tendency to think that if someone has a medical diagnosis of being of unsound mind, or what the old law called a lunatic, they're automatically barred from testifying.
And they aren't.
No, not at all. The test is not a medical diagnosis. It's a functional one applied at the moment of testifying. A person might have a severe mental illness, but if, at the time they are in the witness box, they are having a lucid interval, if they can understand the question, did you see the accident, and give a rational answer like, yes, the red car ran the traffic light, then they are a competent witness.
So a person with a mental illness is not incompetent unless their condition at that moment actually blocks their understanding or their ability to give a rational answer?
Precisely. It's about the capability to communicate perceived facts, not about a medical label attached to them.
That leads us directly to the most sensitive and challenging category, the child witness.
Tender years. This is always a significant challenge for a trial judge. A child is not automatically incompetent, but a child is also, by nature, very suggestible, and their understanding can be limited.
So how does the judge check? How do they apply that two-part test to a 5-year-old?
The judge will usually conduct a preliminary examination called a voir dire.
Voir dire. Sounds very formal. What does it actually involve?
It's really just a chat. Before the lawyers get to start grilling the child about the crime, the judge will have a gentle conversation with them. Simple questions. What is your name? Do you go to school? What's your teacher's name? Do you know the difference between telling the truth and telling a story or a lie? What happens if you tell a lie?
So they're checking the operating system before they try to run the complex application.
That is a perfect analogy. The judge is testing the child's basic intelligence and, most importantly, their understanding of the moral duty to speak the truth. The landmark case here is P. Ramesh versus State from 2019. The Supreme Court held that the core capability is simply the ability to understand the event they witnessed and then communicate what they witnessed truthfully.
But there's a big but here, right? Even if the child is found competent, their evidence isn't treated the same as an adult's?
No, it's not. And this is the rule of caution, which comes from the case of S.G. Mohite versus State of Maharashtra.
What is that rule?
The rule is that the evidence of a child witness must be scrutinized with extreme care and caution. And why is that? Because children can be easily tutored.
Just go in and say what Daddy told you to say.
Exactly. Or they can innocently confuse their imagination with their memory.
Ah.
So while a child is a competent witness, it is considered very dangerous and unsafe to convict an accused person solely on their uncorroborated testimony. The court has to be absolutely sure that the child isn't just reciting a script given to them by an adult.
Right. Now we arrive at a section that has seen a massive and very welcome upgrade in the new law. Section 125, the mute witness.
This is a fantastic example of the BSA modernizing the old IEA. Section 125 deals with a witness who is unable to communicate verbally.
In the old days, I think the term used was dumb witness, which is obviously archaic and offensive terminology now.
Yes, thankfully the language has evolved. The core legal concept remains. If a witness cannot speak, they can give their evidence in any other manner in which they can make it intelligible. So, through writing or through signs and gestures in open court.
And here's a classic fact-check question from the notes. Is this considered written evidence or oral evidence?
It is deemed to be oral evidence. That is a classic preliminary exam MCQ trap. Even if the witness writes down their entire testimony on a pad of paper while in the witness box, legally, it counts as oral testimony, not documentary evidence.
But the procedure for taking this evidence has changed significantly in the BSA.
It has, and for the better. The BSA now mandates a 3-step protocol to ensure fairness and accuracy. Step 1 is establishing the witness is unable to communicate verbally. Step 2, the court shall take the assistance of an interpreter or a special educator.
Special educator, that phrase wasn't in the old law, that's new.
It's brand new. It's a very thoughtful addition. It recognizes that communication barriers aren't just about translating a spoken language. They might involve cognitive differences or specific complex sign languages that a regular interpreter might not know. The law is now asking for genuine experts.
And what's step 3?
This is the real game changer. The statement shall be videographed.
So mandatory video recording of the testimony.
Yes. And think about why that's so important. In the old system, an interpreter would watch the witness make signs and then say to the court typist, he is saying the car was blue. But what if the defense lawyer thinks, wait a minute, that sign looked more like the sign for green to me? Without a video record, there is no way to ever go back and verify the accuracy of the interpretation.
The permanent record was just the interpreter's words, not the witness's original signs.
Exactly. Now, with mandatory videography, we preserve the original testimony, the signs, the gestures, the facial expressions, the full context. It protects the integrity of the evidence and allows for appellate review. It's a huge, huge step forward for accessibility and for truth finding.
I love that. It really does level the playing field. Okay, let's move into the world of secrets. Privileged communications, sections 126 through 128.
Right. The law recognizes that some relationships are so vital to society that they need a cone of silence around them, even if it means the court loses out on some evidence. Let's start with the most personal one, spousal privilege, section 128.
This is the pillow talk rule, right?
It is. Section 128 says, No person who is or has been married can be compelled to disclose any communication made to them during the marriage by their spouse.
Has been. That phrase is doing a lot of heavy lifting there.
It's absolutely vital. It means the privilege survives the dissolution of the marriage.
So even if I get divorced from my spouse,
Even if you get divorced, even if your spouse passes away, the seal of confidence placed on those communications during the marriage is permanent. If you tell your wife a secret today and you divorce next year, the prosecution cannot drag her into court 5 years from now and force her to reveal that secret.
but why? Why deny the court potentially crucial information?
Because if that privilege didn't exist, the law believes that no married couple could ever speak with true freedom and confidence. It would fundamentally destroy the trust that is the foundation of marriage. Society, through the legislature, has decided that preserving the sanctity of marital trust is, in the long run, more important than getting evidence for one specific case.
Unless there are exceptions, of course.
Of course, the privilege drops if the lawsuit is between the married persons. So if you're in a divorce proceeding or custody battle, you can't hide behind this privilege. Or, critically, if one spouse is being prosecuted for a crime committed against the other spouse.
Right. You can't assault your spouse and then argue, you can't testify about what I said while I was doing it because we're married.
That would be a complete absurdity. The privilege is meant to protect the marriage, not to be a shield for criminals within it.
What about judges? They have their own privilege in Section 127.
Yes, judges and magistrates have a very specific judicial privilege. They cannot be compelled to answer any questions regarding their own conduct in court as a judge, or about anything which came to their knowledge in court as a judge.
So you can't put the judge on the stand and ask, Your Honor, why did you make that disapproving face when my witness was speaking?
Exactly. It protects the finality of their decisions and the dignity and independence of the bench. But there is a fascinating exception. They can be examined as to other matters which occurred in their presence whilst they were so acting.
What on earth does that mean?
Imagine a judge is sitting on the bench, presiding over a trial. Suddenly, in the middle of the courtroom, a fight breaks out between the lawyers and one stabs the other. In that moment, the judge is an eyewitness to a crime. Witnessing that stabbing isn't part of their judicial conduct, it's a crime happening right in front of them. For that fact, what they saw happen, they can be called as a witness.
That makes sense. Okay, now let's talk about the biggest player of all, the government, affairs of state, sections 129 to 131.
This is where the state can try to play its top secret card. Section 129 says that no one is permitted to give any evidence derived from unpublished official records relating to any affairs of state, except with the permission of the head of the department concerned.
The word unpublished seems to be the crucial loophole there.
It is. And the case law of Yashwant Sinha versus CBI from 2019 blew this privilege wide open. This was the famous case related to the Rafale fighter jet deal.
I remember this. The government was arguing that certain documents were stolen from the ministry and were protected by the Official Secrets Act.
Correct. They claimed privilege. They argued these are secret state documents and the court cannot look at them. But the Supreme Court pointed out a very simple modern reality. These documents have already been published in full in the Hindu newspaper. They are all over the internet. They are in the public domain.
The cat was well and truly out of the bag.
Exactly. The court ruled that you cannot claim privilege for a document that is already in the public domain. You cannot claim something as a state secret when every citizen with a smartphone can read it online. The purpose of the privilege is to maintain secrecy, and once secrecy is lost, the privilege is lost too.
It effectively stops the government from using secrecy as a tool just to hide potential embarrassment.
That's the practical effect of the judgment, yes.
Now let's look at the privilege that affects lawyers directly. The attorney-client privilege. This is covered in Section 132, specifically the proviso.
This is one of the oldest and most sacred privileges. The communication between a lawyer and their client is supposed to be inside an absolute bubble of confidentiality. But Section 132's proviso acts as the broken shield. It tells us when that shield shatters.
So when does that bubble of confidentiality burst?
There are two very specific scenarios where the privilege evaporates. One, any communication made in furtherance of an illegal purpose. And two, any fact observed by the lawyer showing that a crime or fraud has been committed since the commencement of their employment.
Okay, the notes from Satendra Sir have these great illustration cards. Let's role play them to make this really sticky for the listeners.
Sounds good. Let's do scenario A.
Okay, I'm the client. I walk into your law office, I sit down, and I say, I have committed forgery. The police are investigating me. Please defend me. Is that communication privileged?
That communication is absolutely protected.
But why? I just confessed to a serious crime.
Because the crime is in the past. You are exercising your fundamental constitutional right to a defense. My job as your lawyer is to defend you against that past charge. And to do that, I need to know everything. I cannot then run to the police and tell on you. That would destroy the entire legal system.
Okay, makes sense. Now, scenario B.
Go ahead.
I come to you again. This time I say, I want to acquire a property. To do that, I am going to forge a deed. I need you to help me file a lawsuit using this fake deed to get the property.
That communication is not protected. The privilege is gone.
Why the difference?
Because you're not asking me to defend you for a past crime. You are asking me to become your partner in a future crime. You are trying to use my legal services as a tool to further an illegal purpose. I cannot be a co-conspirator in your crime. The shield does not cover future or ongoing criminal activity.
Okay, one more. Scenario C.
Let's hear it.
You're not my lawyer, you're an accountant, and you've been hired by my company. While you're auditing the books for the last quarter, you discover that I, the CEO, am currently embezzling funds. It's happening right now.
That discovery is not protected. This is a fact you have observed, showing a fraud being committed since the commencement of your professional employment. It's an ongoing crime you've discovered in your professional capacity. You cannot hide that behind a shield of professional confidentiality.
So the timeline is absolutely everything. Past crimes are protected for the purpose of defense. Future or ongoing crimes are exposed.
That is the golden rule you need to remember for the exam.
All right, moving on to Section 137, the criminating answer. Now, this feels like the Indian equivalent of what you see in American movies. I plead the fifth.
It feels like it, but it's critically different. And this is a major point of comparison. In the U.S. system, a witness can refuse to answer a question if it might incriminate them. In India, under Section 137, a witness generally cannot be excused from answering a relevant question just because the answer might criminate them.
So the judge can actually force me to speak, even if my answer is a confession to a crime.
Yes. If the question is relevant to the facts of the case being tried, you must answer it. The law prioritizes getting all the relevant evidence for the current trial above your desire not to incriminate yourself.
But doesn't that violate my fundamental right against self-incrimination?
That's where the proviso to the section comes in. It's a crucial trade-off. The law says, we will compel you to answer, but in return, we will grant you immunity for that answer.
What kind of immunity are we talking about?
It's a twofold immunity. One, you cannot be arrested or prosecuted based on what you say in that answer. And two, that answer cannot be proved against you in any other criminal proceeding.
So I'm forced to sing, but the song itself can't be used to put me in jail for that crime.
For that specific crime revealed in that answer, yes. But there is one major exception, the trap door.
And what is that?
If you lie. If you give false evidence while you are under this compulsion to answer, the immunity vanishes for the crime of perjury. You can be prosecuted for lying to the court.
So the deal the law offers is, tell the truth, and you are safe from prosecution for that truth. But if you lie, we will prosecute you for the lie.
That is the deal, exactly. The case law of our Dinesh Kumar versus State from 2015 goes into great detail about what constitutes this compulsion.
We are in the home stretch now. Let's tackle the most complex character in any courtroom drama, the accomplice. Section 138.
The particeps criminis, the partner in crime. As we teach at Target for IQ, this section is a real minefield for students because it involves an apparent conflict between two different sections of the Evidence Act.
Okay, let's set the stage. My partner in a crime gets caught. Can they testify against me?
Yes. Section 138 is very explicit. An accomplice is a competent witness against an accused person. There is no bar on them testifying.
Okay, so they're allowed to speak. But can I be convicted just on their word, just their testimony alone?
Here's where it gets tricky. The section goes on to say, a conviction is not illegal merely because it proceeds upon the uncorroborated testimony of an accomplice.
Not illegal. That sounds hesitant. It doesn't sound like a ringing endorsement of their testimony.
It isn't, and here's why. If you flip back in the BSA to Section 114, Illustration B, which deals with presumptions of fact, it says the court may presume that an accomplice is unworthy of credit unless their testimony is corroborated.
Hold on. So Section 138 says it's legal to trust him, and Section 114 says he's probably a liar, you shouldn't trust him. That sounds like a direct contradiction.
It's the classic clash in evidence law between strict law and judicial prudence. The strict law in Section 138 says you can convict, but prudence in Section 114 says you probably shouldn't. An accomplice has every reason to lie to save their own skin, to get a lighter sentence, out of spite.
So how do judges resolve this conflict in practice?
They follow the rule of prudence. This was solidified and explained beautifully in the case of Mohammed Hussein Umar Kokra versus K.S. Dalip Singhji. The courts have created a rule of practice that is now as firm as a rule of law. While it is technically legal to convict on an accomplice's word alone, in practice, courts always require corroboration.
They need some kind of backup evidence.
Yes, and not just any backup. They need corroboration in material particulars, and most importantly, that corroboration must come from an independent source.
What about if you have two accomplices? Can one accomplice corroborate the other? If my two partners in crime both testify and say I was the mastermind.
No, that is the biggest trap of all. One tainted witness cannot wash another tainted witness clean. If they were partners in crime, they could have easily coordinated their lies together before the trial. You say this, I'll back you up. Two liars don't make a truth. The corroboration has to come from a source completely outside their criminal circle.
That's a fascinating psychological check built into the law. Okay, finally, let's wrap this up with the numbers game. Number of witnesses, sections 139 to 141.
This is the principle of quality over quantity. Section 139 states very simply, no particular number of witnesses shall in any case be required for the proof of any fact.
There's a Latin maxim for this too, isn't there?
Yes, and it's a good one to remember.
Yeah.
Testimonia ponderanda sunt, non numeranda.
Evidence is to be weighed, not numbered.
Exactly.
Yeah.
It doesn't matter if the prosecution brings one witness or 50 witnesses. One single, credible, trustworthy witness, as held in the case of Bivaji Dulu Patil, is sufficient to secure a conviction.
So if I bring a busload of liars to court, I can still lose against one honest person with a clear story.
Precisely. And the judge acts as the ultimate gatekeeper under sections 140 and 141. It's the judge's job to decide on the admissibility of evidence. When a lawyer wants to present a piece of evidence, the judge asks, how is this relevant? And decides whether it even gets to be considered.
This has been a marathon session through Part V of the BSA. We've gone from the presumption of police regularity all the way to the intricate dance of estoppel, the modernization of mute witness testimony, and the broken shield of privilege.
It's a very dense and important area of law. But for the students listening, the PCS-J aspirants, this is high-yield territory. These sections are full of questions for both prelims and mains.
Let's quickly recap the section mapping for them, since that's changed from the IEA.
Right. It's important to know the new addresses. Estoppel, which was section 115 in the old IEA, has now moved to section 121 in the BSA. The accomplice testimony, formerly section 133, is now found in section 138.
Knowing those new numbers is half the battle in the mains exam.
And, as the final slide in the Target for IQ notes always says, revision is the key to retention. You have to know the section numbers just as well as you know the concepts themselves. There's no substitute for repeated revision.
Before we sign off, I just want to leave everyone with a final thought to mull over. We talked about Section 125, the mute witness, and the new mandatory inclusion of special educators and videography.
Yes, modernization.
It really feels like the law is finally acknowledging that truth isn't just about who can speak the loudest or the most eloquently. It's about ensuring that everyone, regardless of their physical or cognitive ability, has the proper tools to be heard accurately and fairly. It feels like a move from a system of just formal justice to one of functional, accessible justice.
I think that's a perfect way to see it. It's a clear sign that the BSA isn't just a rebranding of the old law. It's a genuine attempt, under the guidance of legal minds like Satendra Sur and others, to fix the cracks where vulnerable people used to fall through the system.
Well said. That wraps up our deep dive on Part V of the Bharatiya Saksha Adhiniyam. A huge thank you to Satendra Sur and Target for IQ for providing such detailed source material for our discussion.
And to everyone listening, keep studying and keep revising.
We'll see you on the next dive. Goodbye. Let's understand the next point from here.
All right. So what we're looking at first on slide 1 is really the title slide. And it immediately sets a very serious tone. You see this dark, heavy legal book with a gavel resting right on top.
It looks imposing. The lighting is very dramatic. It gives you a sense of weight, of authority.
Exactly. And that's the perfect mindset for this deep dive. Because we're not just reading a list of sections today. We are exploring the Haradia Saksha Adhiniam 2023, and specifically Chapter X.
And the course material we're working from Target for IQ, it calls this the procedural anatomy of a trial. I love that phrase.
It's the perfect phrase for it, it really is. Procedural anatomy. If you imagine a trial as a living, breathing thing, then these sections we're about to cover, sections 139 all the way to 168, they are the central nervous system. This is the examination of witnesses.
This is where cases are won and lost, right?
Absolutely. This is where it all happens. You can have the most brilliant case on paper, the most thorough investigation, but if you don't understand the mechanics of getting that information from a witness's mind and into the official court record, well, you really have nothing.
And for anyone listening who is preparing for their judiciary exams, I mean, the source material has a huge exam alert box right on this first slide. It's impossible to miss.
Yes, and that's there for a very good reason. This is what we call a high-yield area, especially for the PCS-J mains answer writing. As we always emphasize in our classes, under the guidance of Satendra Sir, mastering Chapter X is non-negotiable.
So understanding these sections is like understanding the art of the trial itself.
It is. And we're going to break it down just as Target for IQ. It's systematically, logically, and always with an eye on how it applies to your exams.
Okay, so let's get into that structure. Slide 2 gives us the roadmap. The visual is quite clever. It shows this journey with 6 distinct stops, each one marked with a gold wax seal.
And the backdrop is a witness stand under a single spotlight. It really, sets the stage perfectly. It tells you that the witness is at the center of this entire process.
It's not just a dry list of sections. It feels like we're building something.
We are. We're building a complete understanding of trial procedure. So let's quickly walk through this roadmap. Module 1, our first stop, is the foundation, which covers quantity and admissibility in sections 139 to 141.
The basics.
The absolute basics. Then Module 2 gets into the mechanics. It's called the triad of examination, covering sections 142 to 145.
I'm guessing that's chief, cross, and re-examination?
You've got it. Module 3 then gives us the tools of the advocate. This is the fun part for many leading questions and contradiction, sections 146 to 148.
The courtroom drama stuff.
To an extent, yes. Then Module 4 sets the boundaries. It's the limits of cross-examination, which is a big chunk, sections 149 to 156. This is about fairness.
Okay. And after that,
Module 5 gets into credibility and hostility, sections 157 to 160.
Right.
What do you do when your own witness turns on you? And finally, Module 6 wraps it all up with memory, documents, and the judge's power, from section 161 to 168. And the whole thing concludes with a look at improper admission and repeal. Understanding this flow is vital for structuring a long answer in your mains.
It really covers the entire life cycle of a witness's time in court. So let's step onto that first wax seal. Module 1, the foundation. We're on slide 3 now, which is all about section 139, the number of witnesses. And the visual is, well, it's very direct.
It's a 3D illustration of a gold weighing scale. Describe what you see on it. It's important.
On one side, on the right, there's a huge pile of maybe 20 tiny little weights. They're all stacked up and labeled quantity. And on the left side, there's just one single solid heavyweight. It's labeled quality. And that one single weight is tipping the scale down. It's clearly heavier than the entire pile.
And that single image tells you everything you need to know about the legal philosophy of Section 139. The text on the slide is short, but it's incredibly powerful. It reads, "No particular number of witnesses shall in any case be required for the proof of any fact."
So in plain English, the court is saying, we don't care how many people you bring to the party.
Precisely. It's not a numbers game. The slide also gives us the legal maxim, ponderantur testiculi, non numerantur. The meaning is simple. Evidence is to be weighed, not counted.
And this isn't a new idea, is it? The exam alert box links this right back to Section 134 of the Old Indian Evidence Act of 1872.
Correct. This is a time-tested, fundamental principle of justice that has been carried forward into the Bharatiya Saksha Adhiniam. You don't need a chorus line of witnesses to prove a simple fact. You just need one credible person. One person who saw what happened and can tell the truth about it in a way that withstands scrutiny.
The source material cites a couple of important cases here. Let's start with Biva Dulu Patil v. State of Maharashtra from 1963. What's the takeaway from that?
That case is really the cornerstone for this principle. The court held that the focus must always be on the intrinsic quality of the testimony. Does it sound true? Is it consistent with the other evidence? Is the witness's demeanor credible? A single, unshakable witness is infinitely more valuable to the court than, say, 10 witnesses who are all vaguely remembering the same thing, or worse, just parroting a story they have been told to tell. The court is searching for truth, not just a headcount.
In the second case, Ramnarain v. State of Rajasthan from a decade later in 1973.
That just reinforces the principle. It hammers home the point that quality will always supersede quantity. And for you, as a student writing an exam answer, this is a critical point to make. Don't just quote the section number. You have to explain the philosophy behind it. You have to show the examiner you understand why the law is written this way. It's about ensuring justice, not having a popularity contest.
Okay, that's a very clear foundation. So once you have your witness or witnesses, how do you decide who goes first? That brings us to slide 4, which covers sections 140 and 141. The title is Order of Production and Admissibility. And there's a flowchart here called the Judge as Gatekeeper.
Yes, and that title is perfect. This is a critical procedural junction. We're looking at two different sections here. First, section 140 is pretty straightforward. It just says that the order in which witnesses are produced and examined is regulated by the procedural codes. So, the Civil Procedure Code, or the new Bharatiya Nagarik Suraksha Sanhita, the BNSS.
And if there's no specific role?
Then it's up to the discretion of the court. But Section 141 is where the judge really puts on their gatekeeper hat and starts filtering the evidence itself.
Let's walk through this flowchart step by step. It starts at step 1. Party proposes evidence of fact A.
Right. So imagine you're the lawyer. You stand up and you say, Your Honor, I wish to prove fact A. Now, the very first question from the judge, which is step 2 on our chart, is going to be, is it relevant?
And this links back to the earlier chapters on relevancy.
Absolutely. If the judge is constantly checking if what you're saying actually matters to the case. So if the answer is yes, it's relevant, then step 3 is simple.
Admit evidence.
Straightforward. But the complexity, the real gatekeeping, happens in step 4. The flowchart asks, if fact A depends on fact B, what happens then?
Then we go to step 5, which says fact B must be proved first, or an undertaking given to prove it later.
This is the core of Section 141. The law understands that evidence is often built like a house. You can't put the roof on before you've laid the foundation. If the admissibility of fact A is conditional on fact B being true, you have to prove fact B first.
Or at least promise the court you will.
A very firm promise, an undertaking. But the preferred method is to prove the foundational fact first. It keeps the trial logical and orderly.
The illustrations on the slide are really useful here. Let's take illustration A, which is about the statement of a dead person.
A classic example. Let's say you want to introduce a statement under one of the exceptions to the hearsay rule, like a dying declaration. That statement is your fact A. But for that statement to even be considered admissible, what has to be true?
The person has to actually be dead.
Right. The death of the person is fact B. So before you can stand up and read the contents of that dying declaration, you must first prove to the court that the person who made it has, in fact, passed away. You have to prove fact B before you can introduce fact A.
It seems so obvious when you break it down like that. What about illustration B, the copy of a lost document?
Same exact principle. You want to introduce a photocopy of a contract. That photocopy is secondary evidence, that's your fact A. But the law, as a general rule, demands the original document primary evidence. So before the judge will even look at your copy, you must first prove fact B.
Which is that the original is lost or destroyed or can't be produced for some valid reason.
Exactly. You lay the foundation, you prove the original is gone, and then the gate opens for you to introduce the copy. If you skip that step, the judge, as a gatekeeper, will stop you right there.
And illustration C about stolen property is logic. The prosecution has to first establish that the property in question was actually stolen before they can question the accused about their knowledge of it being stolen.
It's all about logical progression. It prevents the trial from descending into a chaos of unproven assumptions and accusations. Every step must be built on a solid, proven foundation.
Okay, so that sets the stage. Now we're moving into Module 2, the triad of examination, starting with Slide 5 and Section 142. There's a branding note here from the source material that I think is important. It says, as we teach at Target for IQ, clarity in these definitions is vital for your interview stage.
That is such a critical piece of advice. In the interview round for judiciary, the panel isn't always going to ask you about some obscure point of law. Often they go right back to the basics to test if your fundamentals are clear. Confusing these three terms, examination in chief, cross-examination, and re-examination, is a very big red flag for them.
The slide uses some simple gold icons to help differentiate them. The first is for examination in chief, and it shows a person pointing to themselves.
And that's a great visual cue. The definition is examination of a witness by the party who calls him. The icon pointing to self signifies ownership. This is my witness. I called them. I want them to tell their story to the court in a clear, favorable way. It's generally a friendly, cooperative process.
Then the second icon for cross-examination changes. Now it's a lawyer pointing a finger directly at the witness.
The dynamic has completely shifted. The definition is examination of a witness by the adverse party. The other side's lawyer is now in control. Their goal isn't to help the witness. Their goal is to test, to challenge, to scrutinize the story that was just told. They're looking for inconsistencies, weaknesses, and lies. That pointing finger represents confrontation. It's the engine of truth-finding in the adversarial system.
And the third icon brings it back around. For re-examination, it's a person who looks like they're explaining something again.
Right. The definition is examination of a witness subsequent to cross-examination by the party who called him. This is your chance for damage control. If the cross-examination twisted your witness's words or left a misleading impression, re-examination is where you clarify and repair that damage. It's about explaining the matters that came up in cross.
The slide lists some very important case laws. Let's start with Vinod Kumar v. State of Kerala from 2014.
Ah, yes. This case addresses a huge practical problem in our trial courts: the constant deferral of cross-examination. Sometimes a lawyer will examine their witness in chief, and then the other side will ask for an adjournment, and the cross-examination happens weeks or even months later.
Why is that a problem?
It's a problem for several reasons. It harasses the witness, forcing them to come to court again and again. It also gives people time to forget details, or, worse, be influenced or intimidated. The Supreme Court in Vinod Kumar came down very hard on this practice, stating that cross-examination should, as a rule, happen immediately after the examination in chief is finished.
So it's about protecting the witness and the integrity of their testimony.
Exactly. Then there's the next case, Anita Sharma v. New India Assurance Co., Ltd. This is a huge warning for any aspiring advocate.
Why is that?
Because it deals with the principle of tacit admission. It means admission by silence. If a witness makes a damaging statement against your client during their examination in chief, and you, as the cross-examining lawyer, fail to challenge them on that specific point, the law presumes that you have accepted that statement as true.
Wow. So you can't just ignore it and hope it goes away.
You can't. Your silence is taken as your agreement.
Yeah.
You have to put your objection on the record by questioning the witness about it. If you don't challenge it, you can't later argue in your closing statement that the witness was lying about that point. You've lost your chance.
That puts a lot of pressure on the lawyer to be incredibly attentive.
It does. Which leads to the next case, Girish Singh v. State of Uttarakhand from 2020, which emphasizes the need to thoroughly analyze the chief examination before you even begin your cross. You can't just go in with a pre-written script.
You have to adapt based on what was just said.
Precisely. And the last one, Virendra v. State of MP from 2022, deals with repudiating suggestions made to a witness, which is another tactical aspect of cross-examination.
Okay, so we have the definitions. Now let's look at the flow on slide 6. This is section 143, Order of Examinations, and it has a simple arrow process visual.
Yes, and this visual clarifies the mandatory sequence. It always starts with examination in chief. That is labeled as mandatory. You can't have a witness without it.
From there, the arrow points to cross-examination.
But notice the label, if adverse party desires. The other side has the right to cross-examine, but they don't have to. If they think the witness didn't harm their case, they might just say, no questions, Your Honor.
And the final arrow goes to re-examination, which is also conditional.
Right. It says, if calling party desires, if you feel your witness did fine in cross and no damage was done, you can waive your right to re-examine. So chief is the only part that is absolutely required.
But the really interesting part of the slide is the scope rules listed below the arrows. It says chief and cross must relate to relevant facts, but then there's a key distinction.
Yes. It says cross-examination need not be confined to facts testified in the examination in chief. This is a point that trips up many students.
So explain that. What does it mean in practice?
In my examination in chief, I can only ask my witness about the facts of the case. But when you get up to cross-examine my witness, your scope is much wider. You can still ask about the facts of the case, of course, but you can also ask questions that are designed to test the witness's credibility.
Like attacking their character.
Exactly. You could ask, isn't it true that you owe the defendant a large sum of money? Or, weren't you convicted of perjury 5 years ago? These questions have nothing to do with the story they told in chief, but they have everything to do with whether the judge should believe them. The scope of cross-examination is much, much broader.
But then for re-examination, the scope narrows right back down again.
It does. The slide is very clear. Re-exam is directed to the explanation of matters referred to in cross-examination. You can't use it as an opportunity to introduce a whole new topic that you forgot to ask about in your chief.
But there's a big red trappy box on the slide. It asks, can new matter be introduced in re-examination?
And this is the classic exam question. The answer is a qualified yes. You can introduce new matter, but there's a huge catch. You must get the permission of the court first.
And what happens if the judge grants permission?
Here's the trap. If the judge allows you to bring up that new topic, the law then gives the adverse party the right to further cross-examine your witness, but only on that new matter you just introduced.
So you could be opening a can of worms.
You absolutely could. It's a significant tactical risk. As Satendra Sir often cautions in our sessions, you should never open that door unless you are absolutely certain you know what's on the other side.
Very good to know. Let's move to slide 7, which deals with what are called special witnesses under sections 144 and 145. The visual on the left is simple, a hand just passing over a brown book.
That visual perfectly represents section 144, which deals with a person called to produce a document. This section clarifies a very specific technical point. Let's say I issue a summons for a bank manager to come to court and simply produce a customer's bank statement.
So they just have to bring the papers.
Right. If the manager walks in, hands the file to the court clerk, and that's it. Section 144 says they do not become a witness in the full sense of the term.
Which means they can't be cross-examined.
Exactly. The green box on the slide explains the logic beautifully. Producing a document is a mechanical act. Testifying is a conscious act. They haven't taken an oath, they haven't said a word about the contents, they just delivered a package. So you can't cross-examine them unless you formally call them as a witness to testify about that document.
Okay, that's clear. But now contrast that with the visual on the right for section 145, witnesses to character. Here we see a very dignified-looking person actually sitting in the witness box.
And that's the key difference. A character witness is there to do more than just drop off a document. They're there to give their opinion, to testify. If you take the stand and say, in my opinion, the defendant is an honest and trustworthy person, you have just given evidence.
And that means you're fair game for cross-examination.
Absolutely. The other side has every right to challenge your opinion. They can ask, if he's so honest, are you aware that he was fired from his last job for embezzlement? Section 145 makes it clear that witnesses to character can be cross-examined and re-examined just like any other witness who gives testimony.
Now we're getting into Module 3, Tools of the Advocate. This feels like where the strategy really kicks in. We're on slide 8, section 146, Leading Questions.
Yes, this is absolutely fundamental to courtroom advocacy. Understanding when you can and cannot ask a leading question is a core skill.
The slide uses simple chat bubbles to define it. A leading question is any question suggesting the answer which the person putting it wishes or expects to receive.
In simpler terms, it's when the lawyer is basically testifying and just wants the witness to say yes. The answer is embedded in the question itself.
The examples on the slide make this crystal clear. The red leading bubble asks, did you see the defendant holding a red knife at 9 p.m.?
Look at all the information the lawyer has packed into that question. The defendant, the red knife, the specific time of 9 p.m., the lawyer is feeding the entire story to the witness. All the witness has to do is nod or say yes.
And the green not leading bubble is the complete opposite. It just asks, what did you see?
And that's an open-ended question. It forces the witness to search their own memory and provide the details themselves. They have to come up with the who, the what, and the when. It's a much more reliable way to get at the truth from a witness.
So the big question is, when are these leading questions allowed? Slide 9 has a whole table breaking it down, and there's another branding note here. Under the guidance of Satendra Sir, we emphasize understanding the exceptions here, as this is a favorite trap for examiners.
It's a classic trap question, both for prelims and mains. The slide sets up a comparison. Examination in chief re-examination on one side and cross-examination on the other.
Let's take the first column, which covers chief and re-exam. The general rule under section 146(2) is that they must not be asked if objected to by the adverse party.
Right. As a general rule, you cannot lead your own witness.
Yeah.
You are there to elicit their story, not to put your story in their mouth. If you try, the opposing counsel will and should jump up and say, "Objection, Your Honor," leading the witness.
But there are exceptions. Section 146(3) says they are permitted with the court's permission in certain situations.
Yes, and the slide lists 3 main categories. First, for introductory matters, things that aren't in dispute. I can say, your name is John Smith and you live at 123 Main Street. Correct.
Yeah.
Just to get the basics on the record quickly.
It saves time.
It does. Second, for undisputed matters. If both parties agreed that the incident happened on a Tuesday, I could just say, and this was on a Tuesday, wasn't it? No need to beat around the bush. And third, for matters already sufficiently proved. Once a fact is established, you can refer to it in a leading way.
But the rules flip completely for the second column for cross-examination. Section 146.4 says leading questions may be asked.
Here, leading questions aren't just allowed. They're the primary tool. When you're cross-examining, you're trying to control a witness who is likely hostile to your case. You don't want to give them an open-ended opportunity to repeat their story. You want to pin them down with specific yes or no questions. You don't ask, what was the weather like? You ask, it was dark and raining heavily, wasn't it?
And there's a final big red warning box on this slide.
Yes, and it summarizes the most important rule for students to remember. You cannot ask leading questions in chief without permission if the other side objects. That is the default position, and the exceptions are just that. Exceptions.
Okay, let's move to slide 10, which covers section 147, evidence as to matters in writing. The visual is a document icon with a big question mark over it.
Section addresses a specific scenario during an examination. It's about what happens when a witness starts talking about the contents of a document that hasn't been produced in court.
The rule says a witness may be asked about the contents of such a document, but there's a condition.
A very important condition. If the witness starts testifying about what was in a letter or a contract, and that document really ought to be produced in court, the adverse party can object. They can essentially say, Your Honor, stop. If they're going to talk about this document, they need to produce the document itself.
So you can't just have someone describe a document, you need to show the document.
Generally, yes. The best evidence is the document itself. You have to produce it, or you have to first prove facts that would entitle you to give secondary evidence, like proving the original was lost.
The illustration on the slide is a bit nuanced, though. It's about an assault case.
It is. In that illustration, the question is whether A assaulted B. A witness, C, says they heard A tell someone else, B wrote a letter accusing me of theft. Now, this statement is being introduced to show A's motive for the assault.
So it's not really about whether the letter's contents were true?
Exactly. The point is not what the letter said, but that A believed it said that, and that this belief gave A a motive to assault B. In that specific context, the court might allow the testimony about the letter's contents because the focus is on A's state of mind, not the document itself. It's a fine distinction.
A very fine distinction. That brings us to slide 11 and section 148, cross-examination as to previous statements. This looks like a really important procedural section. There's a detailed flowchart on the right.
This is one of the most powerful tools in a cross-examiner's arsenal. This is how you formally contradict a witness using something they themselves have previously said in writing, for instance, in a statement to the police or in a signed affidavit.
The rule starts by saying that a witness can be cross-examined about their previous written statements without the writing being shown to them.
That's the first step. You can test their memory or try to catch them in an inconsistency. You can ask, isn't it true that in your statement to the police you said the getaway car was blue? You don't have to hand them the statement right away.
But the proviso on the slide outlines a specific procedure for contradiction. This is when you want to go further.
This is the critical part. If your intention is not just to ask a question, but to formally contradict the witness, to prove they are lying by using their previous statement, you have to follow a very specific procedure.
Let's follow the flowchart. What's the first step?
The first step is that the witness's attention must be called to those specific parts of the writing which are going to be used to contradict them. You can't be vague. You have to point to the exact sentence or paragraph.
And this has to be done before the writing can be proved as evidence.
Correct. The principle here is fairness. You can't just surprise the witness or ambush them in your closing arguments by saying, aha, he said red today, but he wrote blue in his police statement. The law requires you to give the witness a chance to explain the discrepancy.
So you have to confront them directly with it.
Yes. You have to say, sir, I'm showing you your statement to the police, marked as Exhibit D. Please read this paragraph. In it, you stated the car was blue. Today in court, you have testified that the car was red. Can you please explain this contradiction? You have to give them that opportunity.
The case laws here seem to draw a line between contradictions and omissions. Bishna v. State of WB says some omissions can be contradictions.
Yes. An omission can be so significant that it amounts to a contradiction. For example, if a witness gives a detailed statement to the police about a robbery, but completely omits to mention that the robber had a gun, and then in court they testify vividly about the gun, That's a major omission that contradicts the impression given by their first statement.
But the other case, Laxman v. State of Maharashtra, qualifies that.
It does. It clarifies that this section only applies to contradictions. Not every minor omission counts. If the witness forgot to mention the color of the robber's shoes in their first statement, that's likely just a lapse in memory, not a material contradiction. The omission has to be significant to be used under this section.
We are now entering Module 4, the limits of cross-examination. This feels like where the rules of fairness really come into focus. Slide 12 is about Section 149, lawful questions and cross-examination. The visual is a target with 3 arrows in it.
And those 3 arrows represent the 3 legitimate objectives of asking questions that attack a witness's character during cross-examination, as laid out in Section 149.
What are they?
Arrow number 1 is to test his veracity, basically to find out if they are a truthful person in general. Arrow 2 is to discover who he is and his position in life. Are they a respected member of the community, or do they have a history that might make them less believable?
And the 3rd arrow is to shake his credit by injuring character. That sounds very aggressive.
It can be. The law permits a lawyer to ask questions that might injure a witness's reputation, but only if those questions are relevant to whether the court should believe their testimony. It's a powerful tool, but it comes with great responsibility.
And what about the right against self-incrimination?
The slide notes that under this section, a witness can be compelled to answer a question even if the answer would criminate them or expose them to a penalty. The protection against self-incrimination is handled differently here than in, say, the rights of an accused person.
But there's a huge critical exception highlighted on this slide, the victim shield proviso.
This is one of the most important provisions in the entire Act, carried over and strengthened over the years. It applies specifically to prosecutions for sexual offenses, which are now under Section 64 to 71 of the Bharatiya Nyaya Sanhita.
And what does it say?
It says that in cases where the issue is consent, it is not permissible for the defense to bring evidence or even ask questions about the victim's general immoral character or their previous sexual experience with any person.
So the defense can't try to argue that a victim's past sexual history implies she consented on this occasion.
Absolutely not. The law draws a very bright line. A person's past is irrelevant to the question of consent in a specific incident. This proviso is designed to prevent the re-victimization of the complainant on the witness stand and to focus the trial on the actual facts of the case, not on character assassination. It's a crucial protection.
Okay, that's a very clear limit. But who enforces these limits? That seems to be the topic of Slide 13, judicial control over questions, covering Sections 151 and 152. The visual is a gavel.
The judge is the ultimate referee. Section 151 gives the court the power to decide when a question designed to impeach credibility should be allowed. The court has to weigh whether the imputation is so remote or irrelevant that allowing the question would be an abuse. It has to be something that would seriously affect the court's opinion of the witness.
And the Section 152 adds another layer. Questions cannot be asked without reasonable grounds.
Correct. You can't just go on a fishing expedition. You can't stand up and ask a witness, are you a dacoit, a bandit, just to throw them off balance. The slide gives a great illustration of this.
It says asking that question would be reasonable if you have instructions from your client or some other reliable source suggesting it's true.
Right. If you have a basis for the question, even if it's a serious allegation, you can ask it. But the slide says it's unreasonable if you just ask it at random, with no basis whatsoever, simply to insult the witness. That's professional misconduct.
And what happens if a lawyer engages in that kind of misconduct? Slide 14 outlines the procedure for abuse of examination. And the branding note says, in our judiciary classes at Target for IQ, we teach you not just the law, but professional ethics defined here.
And that's because your career depends on it. Section 153 is the enforcement mechanism. If the court believes a lawyer has asked a question without reasonable grounds, it can report the circumstances to the High Court or to the Bar Council.
So there are real professional consequences.
Serious consequences.
Yeah.
And it continues. Section 154 allows the court to forbid indecent and scandalous questions unless they are directly related to the facts in issue. You can't just introduce scandal for scandal's sake.
And Section 155 deals with questions intended to insult or annoy.
The court shall forbid them. The trap box on the slide sums it up perfectly. A question isn't allowed just because it's relevant. If it is needlessly offensive, the judge can block it. The courtroom must maintain a certain level of decorum.
Okay, one more limit. Slide 15 is Section 156, exclusion of evidence to contradict. The visual is a gold shield blocking the gavel.
This is the principle of finality of answers on collateral matters. It's a very important rule for keeping trials focused. The general rule is this: when a witness is asked a question that's not about the main facts of the case, but is just about shaking their credit, whatever answer they give, you are stuck with it. You cannot call another witness just to contradict them on that collateral point.
Why is that?
To prevent the trial from spiraling out of control. Imagine I ask a witness, "Did you lie on your tax return 5 years ago?" And they say no. If I were allowed to, I could then call their accountant as a witness to prove they did lie. Then the other side could call another witness to say the accountant is a liar, and so on. The main trial would grind to a halt while we have this mini-trial about a tax return.
A trial within a trial.
Exactly. So the law says for these collateral matters, the answer is final. But the green box on the slide highlights 2 crucial exceptions.
What are they?
Exception 1 is if the witness denies a previous conviction. If I ask, "Weren't you convicted of fraud?" and they say no, I am allowed to bring the court's judgment to prove they were. A conviction is a public verifiable fact, not just a collateral issue.
And the second exception.
If the witness denies a fact that tends to show they are biased or impartial, for instance, if I ask, "Isn't it true that the plaintiff is your sister?" and they deny it, I am allowed to call another witness to prove their relationship. Bias is never a collateral issue. It goes to the very heart of their credibility.
We're now into Module 5, Credibility and Hostility. This is where things get really interesting. Slide 16 covers Section 157, Question by Party to His Own Witness.
Yes, this is what is famously known as the hostile witness provision. The visual on the slide is a silhouette of a person walking away from a podium, which perfectly captures the idea of a witness turning their back on the party that called them.
So what's the scenario here?
You call a witness to the stand because you believe their testimony will support your case. They've given a statement to the police that helps you. But then when they're on the stand, under oath, they completely change their story. They say the opposite of what they said before. They have turned hostile.
So what can you do as the lawyer? Are you just stuck?
No. This is where Section 157 comes in. The rule says that the court may permit you, the person who called the witness, to put any questions to them which might be put in cross-examination by the adverse party.
So you get to cross-examine your own witness?
That's exactly right. You can ask them leading questions. You can confront them with their previous police statement under Section 148, which we just discussed. You can challenge their testimony.
If a witness is declared hostile, does that mean their entire testimony is just thrown out?
That is a very common misconception, but no, it is not. Look at the effect mentioned on the slide. Nothing disentitles the person so permitted to rely on any part of the evidence of such witness.
So you can pick and choose.
The Supreme Court has said you have to sift the grain from the chaff. The testimony of a hostile witness is not automatically erased. The court can still believe parts of it that are corroborated by other evidence while disbelieving the parts that seem to be lies. The case law of Christian Jander v. State of Delhi from 2016 is very clear on this. The testimony cannot be discarded altogether.
Interesting. So it just becomes another piece of evidence for the judge to weigh.
Precisely.
Now, slide 17 talks about the other side of this. Section 158, Impeaching Credit of Witness. The visual shows 3 forks.
Yes. Representing the 3 main methods, or prongs of attack, that the law allows you to use to formally impeach or discredit a witness from the other side.
What's the first method?
First, you can call another witness. Their testimony would be simply that they know the first witness, and from their knowledge of that person, they believe them to be unworthy of credit. Basically, I know him, and he's a known liar.
The second method is about bribery.
Right. You can introduce proof that the witness has been bribed or has accepted some other corrupt inducement to give their testimony. This would obviously destroy their credibility.
And the third method?
Proof of former statements. This is about showing that the witness has made previous statements, either in writing or verbally, that are inconsistent with the evidence they are giving in court now.
There's a note that a witness who declares another unworthy of credit can't give their reasons during their examination in chief.
Correct. In their chief, they can only state their opinion. I do not believe he is a credible person. But then, on cross-examination, the other lawyer can ask, why do you say that? And that's when they can provide all the specific reasons and instances for their opinion.
Okay, after all this attacking of credibility, slide 18 talks about the opposite. Corroboration, under sections 159 and 160. The visual is 2 puzzle pieces fitting together.
A perfect image for it. Corroboration is about strengthening evidence, making it more believable. Section 159 allows questions that tend to corroborate the evidence of a relevant fact by showing related circumstances.
The example given is an accomplice in a robbery.
Yes. If an accomplice gives a confession describing the details of a robbery, that's one thing. But if they then also lead the police to the place where they hid the stolen goods, that subsequent conduct, the discovery of the goods, corroborates their confession. It makes it much more likely that they were telling the truth.
And Section 160 is about using former statements to corroborate.
Right. A witness's former statement about a fact can be used to corroborate their later testimony in court about the same fact. The key condition here is that the former statement must have been made at or about the time when the fact took place, or before a legally authorized authority.
So like an FIR, a First Information Report.
An FIR is the classic example. The case law on the slide, Shankar v. State of UP, is crucial here. It states that an FIR can ordinarily be used to corroborate or contradict its author. But, and this is a key point for your exams, an FIR is not substantive evidence of the crime itself. You can't convict someone based only on the contents of an FIR, but it's powerful corroboration. This is what he said minutes after the incident, and it's the same story he's telling today.
We're on the last module now, Module 6, Memory, Documents, and Judge's Power. Slide 19 is about Section 162, Refreshing Memory.
This is a very practical provision that you see used in court all the time. A witness is testifying about an event that happened months or even years ago. Naturally, they might forget specific details.
The process flow on the slide is simple. Witness reads a document, recalls the facts, and then testifies.
And the section lays out what kind of documents they can use. It can be a writing made by the witness themselves at or very soon after the time of the transaction, when the facts were still fresh in their memory.
And what if someone else made the document?
It can also be a document made by another person, as long as the witness read it at that time and knew it to be correct. For example, a police officer reading over their partner's notes from an investigation they conducted together.
And what if, even after looking at the notes, they don't have a specific memory of the event? This is covered by Section 163.
Yes. The witness can still testify to the facts mentioned in the document if they are sure that the facts were correctly recorded at the time. They can essentially say, I don't recall the specific license plate number right now, but I know for a fact that I wrote it down correctly in my notebook at the scene. That testimony is admissible.
But there are rights for the other side here, under Section 164.
Of course. It's about fairness.
Yeah.
If a witness uses any writing to refresh their memory, that writing must be produced and shown to the adverse party if they ask for it.
So they get to see the cheat sheet.
They do. And they have the right to cross-examine the witness on it. They can ask, is that the only thing you wrote down? Did you leave anything out? Keeps the process transparent.
Slide 20 covers the broader topic of production of documents under Sections 165 to 167. The branding note here flags Section 167 as a critical concept for prelims, especially as emphasized by Satendra Sir.
It is. Let's start with Section 165. This is a command. If a witness is summoned to produce a document, they must bring it to court. They can't just decide not to. They can raise an objection to its admissibility or production, but they still have to physically bring it. The validity of their objection is then decided by the court.
But Section 167 is what's labeled the penalty. What's this about?
This section is designed to stop parties from playing hide-and-seek with evidence. The rule is simple. If you are given notice to produce a document that is in your possession, and you refuse to produce it, you cannot subsequently use that same document as evidence yourself without the consent of the other party or an order from the court.
So if you hide it when they ask for it, you lose your right to use it when it benefits you.
Exactly. It's a penalty for non-cooperation. You can't have it both ways.
And that brings us to the final session in this chapter, Slide 21, Section 168. Judge's power to put questions. The visual is a magnifying glass over a book.
And that's because this section gives the judge extraordinary power. The judge is not just a passive umpire. They are an active participant in the quest for truth. This section empowers the judge to ask any question in any form at any time of any witness or party about any fact, relevant or irrelevant.
That sounds almost unlimited.
It's incredibly broad. The judge can also order the production of any document at any time. The purpose is to discover or to obtain proper proof of relevant facts. If the lawyers for both sides are failing to ask a crucial question, the judge can step in and ask it themselves.
But surely there must be some limits. The slide has a red box highlighting them.
Yes, the power is not absolute. First, the final judgment must still be based on facts that are declared relevant under the Act and have been duly proved. The judge can't base their decision on some random information they elicited. Second, the judge cannot compel a witness to answer a question that is protected by privilege, like communication with their lawyer.
And the other limits.
The judge cannot ask a question that would be improper for a lawyer to ask, like a scandalous question without reasonable grounds. And finally, the judge cannot simply dispense with the rules of primary evidence. They are still bound by the core principles of the Act.
So the judge is incredibly powerful, but not above the law themselves.
That's the perfect way to put it.
We've now reached the conclusion of the chapter. Slide 2 briefly covers chapters 11 and 12, which are about improper admission and repeal.
Section 169 is a pragmatic rule. It says that a new trial will not be ordered or a judgment reversed merely because of the improper admission or rejection of some piece of evidence.
So a small mistake doesn't automatically void the entire trial.
Correct. The appellate court has to apply a test, which is on the slide. Would the decision have been the same if the evidence was admitted or rejected properly? If the outcome would have been the same regardless, then the verdict stands. It prevents endless appeals on minor technicalities.
And Section 170 is the formal repeal of the old Indian Evidence Act, 1872, but with a savings clause.
Yes. Any trial, appeal, or investigation that was already pending when this new adhiniam came into force will continue to be governed by the provisions of the old 1872 Act. You can't change the rules in the middle of the game.
Finally, we have slide 23, the mains answer writing strategy. This looks incredibly helpful.
This is where we bring it all together for exam preparation. It lists some probable high-yield questions. For example, discussion on the evidentiary value of hostile witnesses with recent case laws.
That would require discussing Section 157 and cases like Pujapal and Krishan Chandar.
Exactly. Another one is, what are the rules regarding leading questions? Which is a direct call to explain Section 146, including the crucial exceptions.
Explain the procedure for contradicting a witness under Section 148.
That's the flowchart we discussed. You need to explain the two-step process of drawing their attention to the part of the statement and giving them a chance to explain. And discuss the powers of the court to control the examination of witnesses.
That's a broad one. It would cover the judge's power to forbid scandalous questions and their ultimate power to ask any question under Section 168.
It would. And look at the pro tip at the bottom of the slide.
Always cite Bharatiya Saksha Adhiniam 2023 in full in your introduction.
A simple but important point. Show the examiner you are up-to-date and precise with the new law. Don't use abbreviations in your introductory paragraph.
This has been an incredibly detailed journey through the entire anatomy of a witness examination. From the fundamental principle of quality over quantity to the immense power of the judge.
And it all underscores one central idea. A trial is a structured, disciplined, and rule-based search for the truth. Every single rule we've talked about, from leading questions to refreshing memory, is a tool designed to either find the truth or to ensure that the search is conducted fairly.
So as a final thought for our listeners to consider, we've talked a lot about the rules and the structure, especially the victim shield proviso, which protects a specific class of vulnerable witnesses. Thinking ahead, do you think the law might evolve to create similar specific shields for other types of vulnerable witnesses, maybe children or victims of organized crime, further tailoring these rules of examination?
That is an excellent question. It's really at the forefront of legal reform discussions. How to balance the search for truth with the protection of those who are most vulnerable in the courtroom. It's definitely something to watch for in the future.
Something to think about. This has been a fantastic deep dive. Thank you for listening.
Keep studying and keep revising.